Howdy.
No. This product is not intentional. It's hot as well. Oh, yeah. Do all that stuff for it, so. It works as well.
Let's see.
Actually, I'm just putting back soda. I just read that report about cost strokes. Yeah. Yeah, that's good.
Just, okay, that's oh, that's actually, tonight actually is one of those really odd classes where even, when I first taught this class, I was like, actually, they're way more interesting than I ever thought.
No.
So I think, anyway. But then again, it's a matter of, they really are a matter of constitutional interpretation. And it's very interesting how, certainly we'll discuss in a moment, how they came to some of these conclusions, which is kind of like, very interesting, at least constitutionally, but fascinating.
You should get so many documents for all this stuff. All right, let's see the amount of documents you sent me. This many.
Jesus Christ. I'm sure that'll fit in an email.
It didn't, it fit over 6 emails.
Oh, that's why they invented Dropbox.
It actually is why they invented Dropbox.
What?
It actually sort of is why they invented Dropbox. To transfer information around in a more convenient way.
What do you think? Did you have a lot? Did you like the party?
Oh yeah, it was fun. Very
Were
much.
you get the chat, or did you eat a lot?
Yeah, good.
Good.
It was good food.
It was good food.
Yeah.
Did you eat that?
No, it was.
There's some good food.
literally the only active students there were me, a 1L, I don't know her name, spanning 4 weeks.
Oh, her.
And Isabel for half the time, who had to be there for this, who was running the table.
I just say she
And,
was working probably.
and what's her name? Anise, who was there for half the time running the table.
And working.
That was it. There's no other active students there.
Brian didn't go?
Nope.
No previous students, graduates?
Well, Lana went.
Yeah, there was previous
Kelly
students
went.
there.
Oh, there you go.
I'm not gonna go the one day I have to do homework.
Right.
To go and idolize John.
Very
I was scared that I was like, oh, very close.
What?
I was like,
Oh yeah, no, I was reading for tomorrow because there's so much.
Pardon.
Okay. So, okay. I see nothing has really changed,
Negative.
which is probably for the best. So, okay. But for those of you that weren't there,
Where wasn't I?
What happened?
I don't know,
That's what where?
at the show.
Oh,
Oh, you're the birthday party? I was there for a while. I was there for about 2 hours. I didn't
I was
stay.
not there.
You were not there.
Yeah,
Neither were you, I do not believe.
I had 90 pages in this class about 120 in business organizations, another 80 in rent or in community property, and sauna benefit.
Okay.
It's amazing that you made it out of your house.
I didn't.
Oh, you didn't?
It was fun.
Good boy.
That's all I can think.
Yeah, I wish I could have seen you play the guitar. I'm sure it was good. I mean, interesting, you know,
Yeah.
to get up there and play in front of all the faculty and everything. That's cool.
Oh yeah,
Very
I hid in
cool.
the corner, sat in a chair and played.
Oh, really? Oh,
I
okay.
just did the blues thing. I stood there tapping my foot and
Oh, okay.
doing that thing. So
That's cool. That's
yeah, it was
cool.
fun. I had fun. I played the theremin too, which was hilarious.
that's
What is that?
Theremin?
Yeah, I'm not. I'm
It's
not
an electric
musical.
thing that you play, with your hands.
It's a what?
It's an electrical instrument that you play with your hands. You just sort of make sounds with it, and the thing is it's when you play Whole Lotta Love, all those sounds that are in the middle of that are a theremin. And so I bought actually it was a gift someone gave me about 20 years ago. And it's a replica of the theremin that Jimmy Page played. The guy who, they got a hold of a copy of the guy who made it. And so I've always kept that. And
That's so weird. So you just kind of like pretend it's there?
yeah, you just say, you can't, if you touch it, it'll actually start to,
Buzz or?
buzz and things. So, I mean, you can sort of touch it a little bit, but you just sort of move your hands around. And so it does things like, I mean, I can see Jimmy now going, because you can get the same sounds if you try hard enough. But,
Can I play a YouTube video of it? I've seriously never seen the theremin. I've never heard of it.
oh, there's it. You ever hear Good Vibrations? That song by the Beach Boys?
Yeah.
Ooh, that's a theremin too.
Yeah.
It's a different kind of theremin, but it's a theremin. And, where they started to become popular was in the 1950s science fiction movies.
Okay.
Whenever you hear something like that, that was a theremin.
It's the spaceship noises right there.
Yeah, spaceship movies is very popular. So I've always just kept that theremin because, that way they have to let me play. Otherwise, I won't bring my theremin. And I'm not going to hassle.
Why can't you use a violin?
Violins are for
This is the future, man.
how sad.
Sorry.
How bad?
I don't know enough about music to you know.
Well, I mean, the actual answer to your question is because then you have to deal with a violinist. Anyways, you're a musician, you get that. That's serious.
Sounded prejudicial.
They are invariably, as I've always told people, given my brothers, between the violin player and the fiddle player, take the fiddle player. He's every bit as good and not even half the attitude. There you go. Although for those violin players that I know out there, I love you all. Kisses and hugs. Anyway, so with that said, let's go ahead and do what we're going to do today. So the first, just, I don't know why exactly, but it usually happens somewhere around spring break. But now we're starting to get the first kind of, persons are starting to, sign up for bar services and things like that. Most of the ones that are around are starting to advertise for their, for the next summers now. It starts about now, really, and things like that. And see them for November as well, of course. I mean, that makes sense. But so right now is when people are starting to sort of wake up. Now, of course, nobody's going to go, ballistic for the next bar until until they get out of law school. Then you get this big rush at the end. But it usually starts right around April 1st or so, and certainly no later. Spring break's a pretty good time to sit down and kind of really think about what you're going to do. And how you can start thinking a little bit more about the logistics, so to speak. Just how am I going to do this, and not just what, but how. And again, I know I've said this before, and I will say it again, but be very realistic. Whatever you have, okay? And what I mean by that mostly is time, okay? If you have to work, take that in consideration. If you can take as much time off as possible, just take it. Just take it. Really, I'm serious. You want to pass the first time. So don't think twice, right? Just take the time. Anytime that anyone wants to give you off, short of quitting, which I did.
I did.
But there was a reason for that, yeah. And there was actually two reasons for that, and both of them turned out just fine. Anyways, that's in the long run. So, but yeah, but it's all about time. It's going to be about time. And so whatever your plan though is, just plan ahead based on the time that you will reasonably have. Because there does come a point, and it was a very interesting discussion. I was talking not this Saturday, but last Saturday. Actually, I was talking to the one else about getting ready for the baby bar. And it's an odd thing, but because, well, what do you think they always ask me? Do you know who's going to pass and who's not? Generally speaking, I know about 2 months out on the baby bar, whether you're going to pass or not. By a month in, I'm pretty sure. You have to kind of shock me if you pass. And it's really not, any great, when you do it enough, it's just not any great prognostication. It's just, this is where you're at. This is how much time you have left. So unless you're unusual, unless you've got something going on, you never know. You could be, I once had a student once who I could never understand how she did everything at the last minute, and how everything was just always really perfect and everything, not perfect, but almost perfect, and then et cetera, et cetera, et cetera. And then I found out she was married to a judge. Well, that answered a lot of questions. So you have your walking, she had a walking, talking, code book, a walking, talking case book, a walking, talking wool corpse. So she had a secret weapon, that most persons don't have. And so if you have a secret weapon, that's great. I just always assume everybody's just normal, everyday person, right? Because I don't know, right? But now that I've said that also, I do want to warn you, because I have also known other persons who have been either married or, related to lawyers, and they say, oh, don't worry about it, I'll just help you. We'll just wait till the last 3 days and I'll just teach you everything. Don't do that. It really doesn't work. You laugh. I've actually had several people tell me that over the years, that he's just going to tell me exactly what to write in the last 3 days. I have a great memory. I'm going to pass. Okay, that is the person that has never passed.
I was about to
To
say,
this day, she has, well, she's given up since my day, but she never passed. I was told she took the bar 11 times and then gave up. But to me, it spoke for itself. And again, she was one of those, the girl can have it all. I can do a job and da-da-da, and da-da-da, and da-da-da. One of the great, not women, but one of the great arbiters of your time, one of the great barriers you will have is the bar. It's just, it is to a great degree just a matter of time. The problem with brilliance on the bar is it shoots you over the bar. Think about it. Think about what I just said. You might be Cardozo, but Cardozo, I'm telling you, is going to fail the bar unless he committed himself to study like a normal human being with a normal brain when it rubs at you. Invariably, he would shoot over the bar. And he may be solving, the mystery of the universe on paper, and no one's ever going to know. So it's kind of sad that way. But nonetheless, that's what kind of happens. It's not like mathematics. Mathematics is very different. There are those among us who are just brilliant. They just are. And so with mathematics, it has certain rules and regulations. The smarter you are, the better off you are. It's just the way it is. Law's not like that. It's shocking. Matter of fact, many, many times, intelligence actually hurts you in the bar, particularly when you get to the level of a Cardozo, because you're talking about the way law that you think it should be. Now, if you're going that far out, you might get on the Supreme Court. Not a bad thing to do, but you're never going to pass a bar talking about what you think the law should be. That's crazy. I mean, think about what I just said. What if someone gave you a paper and it was the most brilliant public policy argument you've ever made for fill in the blank? So much better than what we have today. What a paper, should make it into every newspaper, should be in the ABA journal, and yet here it is sitting in front of a bar grader. So what does it get? 50. Because the bar grader, guess what? Has a list. The bar grader, I'm not saying the bar grader is smart, not smart. I don't care about that. But when you're a bar grader, you're trying to act like a machine as much as you can. Again, this guy gets paid. Yeah, girl gets paid. Same amount of money. Doesn't matter what grade they put on it. Doesn't matter how they do, et cetera, et cetera, et cetera. And so the idea that they're actually going to sit there and somehow, suss out your genius is just that. I would say you're better off thinking that the bar is a member of the deep state and they're out to get you. You'll probably write a better paper. Oh no, this is that Will guy. That never happens, by the way. Although I've had numerous students who've told me they're sure because of something they did in law school. And I said, well, that's also called paranoia, but you don't need a lawyer for that. But anyway, so that's the whole situation in a nutshell, is it really comes down to the bar is very workmanlike. It's very orderly. A lot of it does to its benefit, although, again, it's well, not, it wouldn't be hard for you guys because, you work in the law office and everything. But again, it's geared kind of to see, what would happen if you came into a law office. I guess that's the best I can say for it. Are you willing to take direction? Are you capable of, in my mind, very basic functions of logic? Are you capable of, fill in the blank? Just things that you would probably write very generically on a resume. Yeah, I will not be ready for it. Yeah, I can arrange a paper. Yeah, I have good spell. It's all these things that are just not that weird. They're just not. And to a great degree, they're just sort of looking at the law environment for what it is. And they're seeing if you fit. Is this someone who actually could come out, work in the law office, or maybe even work for themselves and the whole thing, And the bar just has no real attachment, though. And not me saying this, by the way, although I'm saying it, but the bar will not claim that whether you pass the bar or not indicates whether you will be a good lawyer or not. This is not so. They don't have any corroborating evidence if you were to make that statement. So they can't make that statement. Well, we test you because we want to make sure you're a good lawyer. No, we probably just want to check you to take the bar, partly because we don't really want to put any mass murderers out there, and partially because who knows. But they will not tell you that passing the bar makes you a good lawyer. I mean, you would kind of laugh at them if they did tell you that, wouldn't you? I mean, considering, I don't know, I don't have no one's ever done a study, and I think nobody ever will, because I think the results would be pretty stunning in one direction. But, my guess, 50% of lawyers good, 50% bad. I think that's being pretty generous. Laws just, it is what it is. And fortunately, you're getting a lot of it in your lives. Perhaps you will work in an office soon. Who knows? And you're getting a lot of law here, which is good. It's good to be kind of inundated and things like that. But at the same time, that's kind of what you're up against. And so that's how I would kind of be thinking right now, is how am I going to pass the bar? Not what kind of a lawyer am I going to be, what kind of this, what kind of that, although all that stuff's fine. You can think about that too. But really, starting with the Easter break, really start to think about the mechanics of what you're going to do, right? The best way to think about it, and I will tell you this numerous times before you actually start, is the best way to think of it is don't disconnect the three. Okay, in other words, I got the little graduation thing in the mail today. I have to order my graduation gown. So, which fortunately for me is $50 because last time I looked I hadn't grown. So I'm pretty okay with all that stuff. My head might have after Sunday's extravaganza. Anyways, but just school, study, bar, out. Just think of it as one thing. Don't stop. Take a couple of days off, okay? Do something fun once you graduate, but then go right back into it. Don't go sideways. Don't go away. Don't do something. Really don't. Take a couple days. I would never hold that against you, but that's it. Get right back into it and just see it as one, that was just your little whatever holiday it was. Take your choice. Pick somebody that you like that doesn't have a national holiday for them. How's that sound? And take a couple of days off. I would, at this point, do, National Keith Richards Day. Just fine. Take a couple of days off. Drink slowly. Do whatever you do. Keith Richards Day like that. But then go into it, and go into it with the attitude that it's part of your job. It's part of your training. It's part of what you have to do. To me, it makes no sense not to do that. It makes absolutely no sense not to do that. Then take the bar. Then, the day after the bar, do whatever the hell you want. I don't care. Nobody else does, and you won't either. Except the next day, you'll probably sleep most of the day. Most people actually do not go to work the day after they take the bar. You'd be kind of surprised. Although, now that it's only 2 days, well, speaks for itself. No one is. But so that's my advice to you is, you're kind of coming up on, again, you're not in the red zone or anything like that, by any stretch of imagination, but you're coming up on some decision making. I mean, April, it's really not that far away when you think about it at that point. Like by your break, that's when you really start to think more nuts and bolts. That's all I'm saying. Not so much theory anymore. Nuts and bolts. How am I really going to do this? Okay, and use the rest of your law school for dual purpose. That's what we're trying to do in this class, by the way, in case you hadn't noticed yet. But we're trying to learn the material, which of course is a good thing to do. And, we can do that in this class. We're doing it just fine, right? But at the same time, let's go ahead and try to turn as many of the lessons as possible into, a little bit of bar training as we can, right? I mean, let's try to do that. Let's try to get the jump on everybody. I don't know why not, right? I mean, when I hear fourth year, the only thing, not the only thing I hear, but the thing that speaks to me loudest is how do we get a jump on everyone else? Okay, how do we use this time to get a jump on everyone else? Of course, in this class, the answer is easy. Study torts and contracts. That's not hard, right? That's easy. Let's go back to that now. Before, in a couple months, you go, I haven't done any torts or contracts in 4 years, which is what I did. What's a contract? Oh yeah, that's right. And so for, so on and so on that. But, you're getting kind of close. That's all I'm saying. I'm saying a lot of people, April, May, June, July, a lot of people, some people have already started, by the way. See, people start, a lot of people start either late January or early February. So I'm telling you right now, there's already people who have started. There's about 6 months is when they actually start to actually do something, like have a daily routine. There are those people that are doing that. But, again, unless you're a certain type of person, that could be overkill, underkill, I don't know. I would never suggest starting any sooner than that, personally speaking. But, now you can be about 4 months out, April, May, June, July. And so more and more people will start. By month 3, people will be doing, when they're not having summer fever, they'll be starting, right? And then by 2 months out, that's when the Barbary people just all, that's when knowledge just so there you go. And so that's basically what you have. So we're looking at now, I'm just telling you this so you are aware of it. There are people that are practicing with a daily routine. Now, it may not be very long either, by the way, but they are doing it already. There's absolutely no doubt. So I've had many students who have asked me to do 6-month programs for them. It's not unusual at all. It's not. But they tend to only be 2 or 3 hours a day at most when you're doing that much. So anyways, but okay. Any other thoughts on the bar? Yeah. Any other thoughts on contracts, torts? Yeah. Any other thoughts on this class? No. Okay, let's move on. All right. So, again, if you have any questions, just let me know. I'm more than happy to answer them. I'm more than happy to make it part of, I'll find a way to make it part of this class. Don't worry. We'll figure it out. So it's a good thing to do. It just is.
Did you guys register yet for the bar?
I have not. I need to get on it.
We're gonna have like a kind of time to go over like the background checks and all that. Cause
Oh shoot! I'll do
is there a
that.
way we can have like a lecture on that maybe?
I personally can't do that for you because it's changed so dramatically since my day that I don't even understand it anymore. I do know you have to be fingerprinted and all this stuff, although when you first was, I was too. But it's become very different. I do know the person you might want to talk to, I think, is AJ. Ask her if she's willing to do it because I think she knows about it. I think she's been helping people.
It's just like a general walkthrough through it. So
Yeah, I mean, to me, it's like, I don't know, you make us some papers. That's what we did in my day. We just,
That was kind of my plan, just to fill it out.
yeah.
But it's really long, and you need recommendations.
Mhm.
Yeah, you do need some recommendations, and there are things that you just have to go over. Disclose and divulge, and they say there's a way to write certain things and a way not to write certain things. I don't know. Nobody helped me do mine. So sort of quick follow there. And in my day, it was quick. It was like, a month later, oh, you're fine. Okay. No manslaughter? Great. That's how it was back then, I think. But today, one of the biggest problems they have is that the background checks are backlogged. I mean, so get them in as early as you can. Kelly still, unless she just recently got it, she still has not made it through. So, and believe me, it has nothing to do with what she did or didn't do. They're just taking forever right now. It's taking up to 18 months. And when I think I got mine back in 30 days, no more than 45, I'm sure.
So it takes 18 months.
Well, we should
Even if we
have,
pass the bar, like if we won't know until we won't be able to practice till like a year later.
Yeah, you cannot practice until you get cleared. And it was almost, I mean, in my day, it was unthinkable that you would even take the bar without being cleared. You would just do it, in, something like March, before you got out of law school, you do it right at the end. So we would do ours in April. I did mine in April. I had it back by, certainly by June. I'm sure it came back sometime in May. And I took the bar and I was already, all I had to do was go get sworn in. You can't even get sworn in until you get your moral application back. So, and if it takes up to 2 years.
I've never heard it taking anybody else that long though.
Oh, I've heard quite a few people.
Have you?
Oh, yeah, that's not unusual. Yeah. Now, fortunately, the older you are, the longer it takes, right?
Why?
More look.
You just
More
gotta
history
look
looking.
through. Just do. So, whereas the younger you are, the less there is to look through. So it's not as, as time consuming. So, but yeah, I recommend you get it in as quickly as possible. My other recommendation is find someone, if you have any questions about something, just ask somebody, say, well, what do you think about this? What do you think about that? And, somebody who's done it before, because, there are people, in my day, it was unthinkable that you would hire somebody to help you with it. I never, ever heard of anyone say that. Never. And today, it's like, I understand there's people out there who will actually help you write your moral application now. Okay. But again, that's something for, I am just so removed from this. I have no idea anymore. I don't even know what it looks like anymore, much less. So, but yeah, you do have to get on that at some point and do not wait till the last minute. That's all I'll say. Can't tell you how long it's going to take, but don't wait till the last minute. That's proving to be a bad idea so far. But anyways, and it doesn't seem to be getting any better. So that's something you might want to consider, where it seemed to be taking longer and longer and longer. So a lot of complaints out there. Okay? All right. All right then. What do I do with my glasses? Oh, there they are. That's a good sign. Right. So how about this? Preventing harm without coercion. What do you suppose that means? Wow. Okay, so we're entering into declaratory remedies. Does everybody have a general idea what a declaratory remedy is? It's a very, very misunderstood part of law, I have to say. You may be a lawyer your entire life, and you may be a litigator your entire life, and you may never hear anybody talk about declaratory judgments. It's not, in my experience, it was not unusual. See, that's kind of why I know about them. Because declaratory judgments, there's a lot of them that you can deal with when you're doing intellectual property. You can go ahead and you can go to a court and get a declaratory judgment whether they think that your patent application infringes on someone else's, whether your copyright infringes on someone else's, whether you're not so much trademarks, I haven't seen too many of those, but you could do it. That's not a problem. And so you see a lot of that in intellectual property. So declaratory judgments, to me, were fairly well known. I didn't think they were that strange. But since that time, and I've been talking to other people in other types of the law, and they say you can go your entire career and never really run into one. Because they do have, to me, they have a powerful effect, because I've seen what they do. But for the most part, I guess it's understandable that they are really a curiosity, because they're a declaratory judgment as a practical matter. It just means it's a judgment that's unenforceable. Now, why in the world would you want to go to court to get a judgment that's unenforceable?
Well, I would think that you could probably still get claim preclusion, issue preclusion based on a declaratory judgment if it did pop up in a different case of controversy.
Okay.
So it might be a cheap way to do it without the litigation aspects involved.
Cheap is good, very good. That's why the clients I have to do them, because it would basically
Force the issue.
It would be like taking medicine. Okay, in other words, if I'm going to do this, I already have the cure, right? I know that if I go to court, that this court, which is very similar to this other court, has already said that they do or do not think that this is infringement. And so therefore, I've got a court's opinion, right? A verified, bona fide court who has gone ahead and declared, in essence, if this was in my court, right? If this was in our jurisdiction, and this case was actually here, this is how we would rule. And so if you have someone from the same jurisdiction, it's pretty good, right? I mean, the chances of a similar judge in a similar situation ruling the same way, you're in pretty good shape. I mean, particularly in intellectual property where there's really not as much black and white as people, or gray as people think. A lot of stuff's black and white. There is a gray area. So, but that's always going to be, we used to call it the X factor. You just never know in intellectual property. But that's why we usually get them, is we go to court and say, well, this does infringe or this does not. And, you send over this package to the other side and say, my client had a declaratory judgment, da-da-da-da-da, and look at that, right? The judge said that you're infringing, blah, 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 blah. Well, what do you want to do? Do you want to go to court and get the same thing? Or do you want to fill in the blank and get the same thing? Or what do you want to do? Right? And so they do that. One of the other things that a lot of people don't know, which is kind of interesting, which again is something that you can do as attorneys. It's kind of a mediation thing, but you can hold a mock trial. You can actually invite the other side, you can invite a retired judge, and you can actually put on your case. The winner and the loser, right? I mean, it's not binding or anything, but what do you think happens when the loser gets a taste of losing in front of this judge? What do you think happens if you can actually, I have never done this, but I've heard of it several times, not in intellectual property, strangely enough. Get yourself a jury of 6. Put on your trial, see what they say. Not binding, but it's a hell of a lot cheaper than actually going through a real trial. Pay a retired judge $1,000, $2,000 a day. Not a bad idea sometimes. Did you know that actually Judge Judy is a form of ADR?
Well, she was binding though.
What?
Isn't she binding?
Well, she's binding unless you don't want to do it. No, I'm just kidding. No, you theoretically, if you agree to go to Judge Judy, you cannot appeal it.
Is it just kind of like non-binding arbitration, binding arbitration, kind of, sort of?
Yeah, it's kind of like binding arbitration. Yeah, you can't really appeal it. And, and it's only my understanding, but I've been told everybody gets paid. So you see, you're kind of entering into a contractual relationship as well. And in fact, unless it's against public policy, can you waive your right to go to court? Absolutely. It's a waivable right. Unless it's against public policy, then you can't do it.
So for the sake of the show,
Yeah.
everybody gets paid.
So the plaintiffs and defendants both get paid?
Well, they get paid their appearance fee, and then if
like
their appearance fee is less than whatever the judgment is, then they owe above and beyond that, probably.
Well, I have been told that the most you can get is $5,000.
Yeah, the most you can get on Judge Judy is $5,000 because
It's
she says
$5,000.
she's small claims.
Yeah, because she has limited jurisdiction, right? So, but she can award that to you, and that's a real award. So, and it does have a binding effect.
Yeah, because my mom used to watch it, and people would walk out and be like, "You're not a real judge. It doesn't really matter what you do here." And they'd leave the courtroom, and she'd be like, "Actually, contrary to what they say, I am a real judge, and everything I say here is binding on them as a judgment."
Oh yeah,
So
you can be denied the right to appeal, and also if you were on Judge Judy and then you got sued and you had that judgment, they may very well throw out the case right there and then. It is a kind of well, of course, in this day and age, anything that's ADR, it's like fabulous, great. We should have 3 ADR clerks going 24/7 here. You probably can do it if you try.
It'd be a great way to make money.
they do it as fast as Judge Judy.
I know, she's awesome.
Like, you're wrong, they're right, get out, goodbye.
I would have a hard time, I would scrutinize it if I were a judge.
Yeah, I was gonna say, if you bring up one of her shows and
Their
they
procedural
do it
rights have
45 seconds, I mean,
It's
it's not like
literally
it seems like it's like a violation of due process, because she's just like,
you agree.
Yeah.
You know, hey, who told you you're gonna get a fair shake in real court? Sorry,
Well,
I'm not
but
when I say that.
I don't think that a contract to agree to a
Just
conflict should stand. I mean, do you think so? Do you think a contract to agree that we're gonna flip a coin should be upheld as preclusive, having preclusive effect?
If it's not against public policy, yes.
Do you agree to it?
I don't think so against public policy. I don't think you should ever be able to waive, you've been discriminating against me or something. I don't care, that's ridiculous. Or you can defame me in any way, shape, or form, and I don't care. Both of which I've seen in contracts, by the way. You can't, it's just against public policy. You can't have those things.
But you could say, heads you defamed me, tails you didn't, and we can flip a coin and that'll have preclusive effect on the court. That seems like just
But what if you
unfair.
agree? What if you're, knowing, voluntary consent?
I guess, yeah.
Yeah.
You can contract almost
I mean,
anything, whatever
if you-
you really
if-
want to.
If you can consent to a boxing match, why can't you consent to that? If you think about it. So, anyway, but even in a boxing match, you don't consent to have people hiding things in their gloves, right? So, again, there's always going to be some things that you can consent to, and there's always going to be some things that you can't consent to. The thing that actually I find very strangely attractive about what you said, flipping the coin, is because you're leaving it totally to chance.
Right, well,
I
that's,
don't think I would want to do that personally.
right. But would that be a judgment?
I don't know. Let's find out. To me.
Yeah.
I don't know. The answer is probably, strangely. I'm not sure. Yeah. But these are things that as you go forward in your careers, whether you, again, whatever it's worth, but whatever you're thinking now, it's like you will start to look for more ADR opportunities. It really is going to help. And with the way that the courts are today, we really should start to think about this. Now, it's only my opinion. Some people will agree with me and some people will disagree with me. That's not unusual. But with that said, not everybody wants their attorney to be a shark. You know why? I'll tell you one reason right away.
Expensive.
Sharks cost money.
Mhm.
That's right. You can run up a lot of hours, a lot of bills, and with a shark, you're going to pay them, by the way. Otherwise, speaks for itself. But at the same time, there's plenty of people who don't want a shark.
Mhm.
And someone who says, look, can we just get something done here so that we can all live happily for the next so many years? A fair contract, or we don't have to, hammer out everything and blah, 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 or whatever else have you. And you see those as well. I really do. I've had many, many clients. I feel very fortunate that have come to me in the intellectual property arena that says, well, you're the guy that just makes it happen. This is the guy that has to sue everyone 10 times, then it happens, and we've already paid. And I was like, oh.
Who knows? Your shark may get arrested for extortion.
Well, he was, yeah.
I couldn't believe it when I saw that on the TV yesterday. I just turned on the TV, and there was Michael. Yeah, know the story?
Oh yeah. Oh, and then today he tweeted all of his bad things about Nike.
Yep.
He's like, all right, here we go.
Did he really?
Yeah, he tweeted everything
Yeah.
Yeah. About Nike paying high school students.
You never make a threat unless you're prepared to follow through on it.
Yeah, well,
And I think that,
he followed through.
well,
Oh, he
Nike tried to call his bluff. He follows through, and now they're going to fight it out. But he's being criminally indicted.
Yeah,
In
for
2
a ton of stuff.
states.
Well, California
for
and
two
New
different
York.
things.
One's
Yeah.
for wire fraud and one's for the extortion.
Yeah.
But yeah, don't sharks are on us.
Well, just out of curiosity, though, I mean, there's one part of that story that let's just discuss very quickly. Because it's really weird, and especially in this day and age where we've already had one example of where the attorney for the National Enquirer thought that basically extorting the richest man on the planet was a good idea. Now, that's a bad idea. So we all agree with that, right? You picked on the wrong guy.
Yeah.
If he wants you gone, you're going to be gone.
Well,
That's not a good idea. Okay, he's got enough pull to make sure that yes. Okay. To make sure that a little, operation like the National Enquirer has a very miserable life. But with that said,
It sounds like, I don't know the rules on extortion, but unless you have a legitimate case, what are you doing asking them for anything?
well,
he
but
was
let's
representing R.
say,
Kelly. And something about R. Kelly and Nike, I think, is what brought it all up.
yeah, that I think.
Because
What's his underlying case though?
something with R. Kelly's child molestation case, I think. I don't know
I
how.
thought it was student athletes being.
Well, no, that's what he started tweeting about, but supposedly the whole underlying thing was between R. Kelly, like the whole R. Kelly issue, because he's supposedly representing R. Kelly in something. And then, because supposedly the indictment against Avenatti helps R. Kelly's case because Nike basically admits something within the indictment that helps R. Kelly's case.
Okay.
I haven't read it enough to fully
I
understand, but that's like the gist of
I
it.
just don't. I haven't seen it.
Well, if that's true.
Because I didn't care enough about anything with R. Kelly that's really investigated further.
But this is what I'm interested in. If it's true, okay. So let's just first of all assume that. Let's assume the case is good because it's more interesting if it's good. If it's a bad case,
Avenatti's case is
yeah,
good.
let's say Avenatti's case is good. It's got a solid case. Let's assume that because it's more interesting now.
Yes, underlying case.
I feel like there's a very thin line between settlement negotiation and extortion.
Here we go. Now.
Because parts of the indictment that I read where he's asking for his 20 million or whatever,
Do you
it
think?
really
But
seems like
look how he did it though. He said, "You got to catch this stuff. Is this extortion? What we want you to do is give me and my firm, I will, head it up, $20 million to do a report to make sure that you find all the problems in your company, and then you never do it again." Well, companies do that. Okay, they do actually have outside persons, sometimes lawyers. I've done it on a very small scale. Nike has never asked me to do that. But I have gone into small businesses, and it used to be really funny when I was still doing employment law, so many years ago. But it's still the same today. It's like a lot of small businesses would actually, call the firm I was working at, and they'd say, "Can you come over and can you bring us up to code?" And we'd say, "Of course." And it was always the same. First of all, always the same thing because you have more than like
Here's a confidentiality agreement to start before you get your foot in the door. Well, absolutely. Because the thing is though,
always
is
stuff that's
like
always.
Walter Clark's, who's a plaintiff's attorney, his new advertisement about pools says that you should call the city and request an inspection of your pool. And I'm like, a defense attorney would never tell somebody to just request an inspection. Like they would go get your own inspector to determine. Don't go ask the city because then you're under. He, as a plaintiff's attorney, can now prove notice with a city inspection. Like it seems like that's horrible advice. It's advice against their interests, and I think it might be bad. It might be in the PR department over there, maybe inappropriate for him to give radio advice that would to people that would set him up in a way that would help a plaintiff later on when he's the biggest plaintiff's attorney in the valley. Just it popped in my head. I'm a weird thinker like that, so I don't know. But it seems inappropriate, right?
I mean, it does seem curious. It does seem that's. I mean, it's interesting.
I'm not sure if he's thinking that way. He's just thinking like, hey, you should go get inspected. Maybe, maybe.
Yeah, maybe. I mean, it's funny because the way you put it, it seems rather like a two-edged sword. It could cut both ways.
You should. I mean, if you're gonna give somebody real legal advice, you say, go find somebody that knows the pool code, and then have them
waive a confidentiality agreement, inspect your property, and then remedy the situation, and then go have the city look at it. Don't just walk over to the city. What if the city says, yeah, you're way out of code, you need 30 grand, man.
And they do that.
And they like, oh, I can't. Now you're in this position where do I do what is reasonable and probably take out a loan to protect children? And then what if some child dies in my pool and I was under notice that 30 grand would have prevented this child's death? How much is this child's death worth to the family and the parents and all of that versus my choice not to put proper code, whatever the requirements are, onto my property, right? You think that's where this goes, right?
That's highly possible. I mean, that's an interesting thought. I had actually thought of something that wasn't even quite that dramatic. You invite the city over to look at your pool, and all of a sudden they're looking at your wiring. Maybe we should send a guy over to check your wiring.
Sure. I mean, well, if you invite a city official in your home, I mean, what they can see.
They can look at anything they can see.
Yeah, anything they can see. Yeah.
Anything they can see, they can
And
look at.
And they might be able to one thing on top of another, continue their until you're just screwed. I mean,
Like I said, I mean, it seemed like a two-edged sword when you said that. On one side, yeah, you should know what's right.
Yeah, you should know.
It's a trick, but at the same time, though, you can get, you are taking a chance. I don't know. It's something that could happen.
I think it's bad legal advice. I mean,
Yeah, I don't know. Maybe we should invite him over someday. I always wonder why we never have him speak here.
You did do an MCLE one.
Did you really?
It was our first year
I would like to see that.
for personal injury, and I guess there was like 3 people then.
Yeah, that wouldn't be Wally's style.
yeah.
I think he's an audience kind of guy. Not that there's anything wrong with that, but I'm just saying. So, but what do you think about this Avenatti going in there and saying, we'll write this report for you? Now, what I mean by that is, yes, your first inclination is that's nonsense. But what do you think about it, though?
Well,
I mean, you're going to be lawyers. You really think you should just shoot him out of the water?
Yeah.
Well, in the example you gave right
I would shoot
now,
Avenatti out of the water if he did that.
well, in the example you gave right now, where clients called you to inspect them,
Mhm.
isn't it completely different? Where if you as a lawyer just go to a random restaurant and then there was a guy that did that. You just go to like a random restaurant and be like, "Well, you are really not up to code. How about you pay me to bring you up to code, or I report you?"
Mhm.
But then people do that, don't they?
Oh, yeah.
So then,
Well, sometimes, I mean, it's a strange situation because to some degree, you see, there is a logic to that because there is a statute that if you're up to code or not up to code, that people can have private lawsuits against you. So if you actually find out about some, like say a restaurant, and you find out as an individual, even that, just say that you ate there or something makes it more understandable, and you find out that they had a violation, you can actually sue them because you have a private cause as well as a statutory duty to the state. So you actually can't do that. But the problem is when lawyers turn it into like a hamster wheel, then it becomes against public policy.
because there was a guy that was mailing people like, "Give me $10,000 to sell this now."
And it's really weird because when you do that, it's invariably they'll send you to and go away, which they thought was just fine.
That's what happens at my work because we represent property owners,
Mhm.
and we get there's a lot of hamster wheel people like that want to claim that there's like a fair debt issue here, or there's your toilet paper's too far away.
There's the towel on the counter.
Sometimes, yeah, there was a towel on the
There was not
counter.
that thing.
Whatever, a billion things, and yet they just get paid.
Mhm.
That's the result.
Yeah,
Almost
they
invariably.
pay them to go away.
Almost invariably. It's just
I mean, they
cheaper.
won't pay the 10.
No,
That's why they
well,
ask for 10.
one time we had to because they wouldn't go
Oh.
away, and we it's just cheaper. I mean, because that's at $400 an hour. I mean, 10 grand gets eaten up pretty quick if you go to the litigation. So
That's true.
just don't have them that fall.
Yeah, this is true. And I've seen it. I mean, I've seen
I think it's
it.
fraud. I mean, I really don't like it. You know, I think
Well,
it's
it's
extortion at least.
Yeah, that's what I'm saying. That
Okay,
is
but
kind of
it's
extortion,
not.
right? But
Yeah.
it's not.
It's not legal.
Okay, wait, it is legal.
Yeah.
That's what I'm telling you though.
Yeah, it's legal.
Until it's not.
Right,
Now, that's the question now Abenade's a big player.
Sure.
Okay, now has he gone too far though? I mean, 20 million? Of course,
Well-
they are Nike. That's not even their profit for 1 quarter, I'm sure.
Well, it'll probably be more expensive to actually write the report, So
Well-
it doesn't seem like an easy report to write if it's nation.
Well, and
It's a
here,
brand.
of course, is the other thought that I had is, unlike Michael Cohen, who took money to do such things and then never did anything, I assume Michael Avenatti would do something, which might be a little better.
He overshot his target. I mean,
So, huh?
yeah, the line is that if he asked for $1 million, you probably would have got it. And that's the sick truth of this world, you know? But the fact that he asked for 22 million and got pinched, I mean, I'm never gonna do that kind of law. So to me, it's like, I don't think it's cool, you know?
Okay. No, I'm not arguing with you
Yeah.
at all, quite frankly. I just was curious because again, you're sort of the next generation. Just so you know, my generation, we think that's way too far.
Oh, yeah.
No, you cannot do that. That's a shakedown.
Yeah, well, totally.
Otherwise, I'm gonna put all this stuff out and you're gonna use market share. That's, because see, the thing is, remember though, is like threats of litigation are privileged, right? And if I can say to anybody under the sun, I'm gonna sue you. And you can't, there's nothing you can do to me because anybody can sue anybody. Problem is, of course, when you get to court and it gets thrown out for Phyllis, and then you're in a lot of trouble, right? But threats of litigation are privileged. So Avenatti can say, I'm gonna sue you to the, well, it's his daughter.
What did we learn at
Sue
PR about
people.
that though? I think that is that what I thought that it was like a big deal. You can't make threats of litigation. You have to just sue or not.
Well, that's not true.
Oh, really?
That's not true at all.
I don't remember learning that.
No.
Okay.
There's, well, you wouldn't be able to practice law. You just sue them because you're always making threats to them. I mean, that's why you're there, even if you're not making threats. But no, that's not true. If you want to sue someone, that is actually privileged. So that you can't really get them for.
You get a couple meet and confer letters and then you get a lawsuit for us.
That's pretty good. I mean, that sounds very reasonable. But the thing is, so he can't be dinged for that. But see, the problem he has is that it sounds like that what he's done is he's kind of gone beyond that because now he's sort of threatening their bottom line, which was, I think, was very problematic. On the other hand, he is kind of just stating a fact. So you got to kind of look at yourself and say, well, when is it just a tactic and when is it extortion?
I think it depends on the underlying suit.
Yeah.
I mean, if you're objectively correct in your underlying suit, you are doing a public service, legitimately. Like, if the toilet paper is too far from the toilet for a handicapped person, it's too far from the toilet, it's out of code, and you need to remedy your situation, you need to pay the person to go away, and in the end, everybody's really better off because the next person who's in there can reach the toilet paper. Like I'm serious, right? But I don't understand the causal connection between his case, which apparently has something to do with R. Kelly.
No,
And-
not the Nike one.
Well, or at least
I'm reading
paying
the
off.
indictment.
At least his case, okay, the public good would be is that Nike's not supposed to pay athletes at the high school level, correct? Yes or no?
No, it's fine. It just hurts their. It removes their eligibility from being able to play on an amateur level in college.
Well, that's for sure.
Yeah,
I mean, no doubt about that, yeah.
but there's no like law against him just dropping out of school and being a professional basketball player. No one's like. His NBA rules have to be 1 year removed, but you can play for a big baller brand. You know what I mean? Like seriously though. That's the whole point of.
I don't think if you have a sponsorship with like a high school, you're allowed to pay the.
No, that's what's the AAA now? Like it's big baller brands basketball. They have a basketball league for youth, and they're professional paid athletes. And his idea, this is that LeVar Ball guy. His idea is F this. Let's pay them. Let's have a separate league. They don't need school.
They're not learning anything anyways. Get them out, get them playing, and then once they're 1 year removed from high school, they can go into the pros.
Wow, what's this called?
The Amateur Athletic Association, I mean,
The AA? I'll look this up. That's actually
Associations,
interesting to me. I mean, again, I agree with it, but these things are very interesting to me personally, how they do these things. Because I'm an educator.
oh, it's the JBA, Junior Basketball Association. Yeah. And it's openly for minors.
And they pay them.
Yes.
Well, how old do you have to be to play in this league?
Well, his kid is like 15.
15?
Well, I'll look at it. I don't think there is a real. It's specifically for high school and junior college players. There is an age limit. Is there an age minimum though?
That's very interesting, having done employment law. I mean, I know it can be done, don't get me wrong. There's certain things you can do at 14 perfectly legally, fine.
It's sort of a brilliant idea. It's crazy, but it's a brilliant idea.
Well, but what happens to these guys? I mean,
Yeah, none of them go pro. They end up.
I was going to say, I'm going to assume a very small percentage of these people go pro.
None of them.
Yeah, and I don't think they're going to have a whole lot of other saleable skills other than I played in the basketball league. Nothing personal against basketball players, but that's just one skill. So, yeah. Okay, that's kind of interesting though. Okay. So, I mean, again, I'm just curious because again, my generation says no way that Michael Avenatti is going too far. That's just too much. On the other hand, it is Nike. You are talking about. We talked about this a little bit earlier in this class as well in the same section of think about punitive damages. Well, all the damage that Exxon paid was like 1/4 profit. How much does it really hurt though? To us it sounds like this insane amount of money, but to them it was kind of like, shrug it off kind of money. Didn't want to do it, don't get me wrong, it got their attention, but do you really think they stopped? I laugh because I was in the oil industry, so I know what they did, but that's just okay. Anyways, with that said, so this all kind of plays into the mix, but I do think it is fair to say that there is a point though, where as good, bad, or indifferent as it is, there's two things that kind of strike me about this. One is that in the civil arena, which is where we're in right now, it's all about money, right? And so I don't see how it benefits society to have a company ratchet it up and then an attorney ratchets it up. Well, what do you think happens next? You think they back off and go away, particularly when the threat really isn't something that would be, industry ending something or something? No, of course not. It just becomes an escalating war. Who gets caught in the middle? Everyone else. So how is this in society's best interest? How does this play into public policy? So I would argue kind of from the top down on this one, although, again, take it for what it's worth. Most lawyers don't like public policy. I, again, love it. Most people at this school know that. But public policy alone, I think, demands that attorneys like Michael Avenatti, not unlike the attorney that, threatened Jeff Bezos, even if you're the richest guy on the planet. This is too far. This is not legitimate business. This is not, lying and cheating and stealing is not legitimate business. Okay, and if you fall into one of those categories, and certainly extortion is a crime, right? Then you need to think about that, and you need to think about what you're doing. Particularly in this case, as against and again, and again, you can look at it anyway. I'm just making an argument. But what is the downfall of this that Michael Avenatti's trying to stop? That some high school students got some money. And so this is what you want to do. You want to ratchet this all up for this. And I don't know, I don't know. But again, I'm kind of looking at it from all views, and well, if we're gonna let our attorneys do this, then you really think that's gonna turn out well for the average person? I mean, come on. For good, bad, or indifferent, and then we'll actually use some other remedies today from the book. But because remedies is very interesting. See, it's like, what is the remedies for these things? Remedies, particularly, one of the reasons I like remedies too, by the way, and we'll talk about it a little bit, in a minute again, is because, think of remedies at the constitutional level. A lot of things is like, what are you going to do about it? A lot of stuff. I mean, those civil rights cases, I am all for people that, like their civil rights cases, but at the same time, I think the police have to have a hand to stop the bad guys, right? I mean, I don't want to hinder them from doing that. And do you really think you can always have one without the other? Is it true that sometimes in society there's people that win and people that lose? I mean, can you really make everybody happy? And it's like, so again, we're looking at all these different things, which actually is interesting because one of the things that Will said was it depends on the underlying case. So fortunately, as lawyers, we'll all start there, right? And then just let me worry about the world. You guys don't have to do that anytime. That's just public policy stuff. So, anyway, don't worry, I'll stop the apocalypse. Don't worry. You guys just do right by your clients. That'll be just fine, so to speak. Really is something else though. Anyway, so with that said, okay, so, okay, anything else? We good? Okay, that actually kind of worked pretty well. All right, let's go ahead and look at a couple cases. We don't have too many tonight, right? Declaratory judgments, I think they're interesting. I think that they're very curious. The question I have for you, though, is how does a Supreme Court of the United States, which is not able to issue an opinion, right? Remember that from common law? How do they issue declaratory judgments? Because they do it all the time. They actually can do that.
How can courts do that?
Well, the Supreme Court is not allowed to issue an advisory opinion. Is that correct?
It is.
Can the Supreme Court of the United States issue a declaratory judgment?
Yes.
Why?
Because they consider it a controversy.
And
they are solving the controversy.
well, okay, you can there.
Isn't there a
I mean,
federal
that's
act
actually
that gives them
correct.
jurisdiction over
That's part of
Under
it.
the first case, is there?
it? Well, yeah, under the first case, it's, well,
That's part of it.
that's under the Tennessee Declaratory
You're talking about
Judgment Act.
Okay. 1934.
Well, what else? I mean, that's almost all of it, except they do
1934 is
a
after this case, though.
little more interesting little
That's not-
that they threw in.
The same.
Okay, but even if it's just a declaratory opinion, does that opinion have an effect on the underlying rights in the case? Yes or no? Or is it of absolutely no value to anyone?
Well, it's not of absolutely no value to anyone.
I just told you that when we started the class, remember?
Right.
Now you know why.
Right.
Because they said even that amount, because it will influence where the litigants stand on that issue,
Right.
that's enough that takes it out of
The court said even though that they may be informed
advisory opinion.
advisory opinions, because the fact that no other relief is granted does not render it advisory. The respective rights of the parties are in controversy, and the holding will decide that controversy.
It will in
So-
some way. Yeah.
Right. So
It
you do have
does
to
an
have
effect on
you do have to have respective rights. I don't think that you can just go ask, like, do you like my thing? You know, you have to like say like this compared to that. Like you said in your, I'm going to step outside my sphere of knowledge here, but I think that
I do it all the time.
but I think when you said,
Don't worry.
I think when you brought up not trademarks necessarily, but copyright infringement and things like that, that there is another person's rights out there.
Mhm.
And so there is a controversy between respective rights. And I think that's important. Otherwise, it would just be advisory. If you said, is this a valid copyright? Like, no controversy here. You know, go deal with the patent office, right? But you said, like, you know, compared to this copyright, is mine sufficiently different to withstand a challenge? Now you have respective rights, and a declaratory judgment would have would change the position of those parties with regard to the right.
That's perfect. Okay, it does, and it does. I have actually seen it. So strangely enough, it's one of those things where I agree 100% because I've seen it. I've seen people back off because of it. Well, I mean, what do you want to do? Go to court? If the Supreme Court tells you you're going to lose, think about it. What's the point? Because in the very long run, what might the other party do? Well, just take it to the Supreme Court. So you're just going to get the same decision unless something was weird and came out of it. So again, their decision does not have no effect on the underlying rights of the litigants. It does. It moves the ball in one direction. The fact that nobody has to follow it is, I mean, it sounds illusory, but it's not. It really is not. But it's a much lower level than we think. And so that's one of the things that I find interesting because, you know, remember when we look at con law, right? I mean, rights are very ethereal things, right? I mean, we read some cases about whether the very infringement of a personal right is per se a violation of your right, right? We saw those cases. We did those, right? Yeah, we did. And so, and they are. But the problem is what do you give someone for it? It can be very nominal. So here's your dollar, you know. But on the other hand, I think it's true that any infringement, no matter how small of a right, is in some way damage to that right. It's an intangible damage to an intangible right, but we feel it in the real world, right? We just do. That's what makes it, you know, intellectual property interesting, intangible rights. Common law, same thing, for the most part, intangible rights, right? And, you know, it's the more people realize, that's why people generally have problems realizing how valuable their rights are until they're gone. Then they realize, oh, yeah, I was hurt, but no one's going to do anything about it because it's gone now, which is why never miss deadlines for your clients. So the rights don't come around again. So, you know, think about that. Once it's gone, most rights are gone. So keep that in mind. That'll save you a lot of grief. You know, it's like, oh, I'll just file this and get it back. You may not. And then you are really going to have trouble. So anyway, so it seems to me that these declaratory judgments can, in fact, be a very valuable tool. Again, to the actual, if you, at first glance, you just think to yourself, what in the world good, right? Is a judgment that cannot, as a matter of law, be enforced. But in fact, they can be very valuable. So don't forget about them. Every so often you'll find a client and you'll say something and, you know, you'll start to hear this sort of strange kind of, you know, string or pattern, you know, about how he doesn't, you know, he thinks he's right, but he doesn't really want to spend all that money and go through the 2 years of court. You might just kind of say, well, let's go out and get a declaratory judgment from this court and see what they would think. You go to district court, see what they would think about it. You're going to do copyright or patent or something, and see what they think. You know, and a lot of times your client, you know, will be very interested because it's for one thing. Oh, it's way less expensive,
right?
I mean, for sure. And you know, it's a pretty good. No, you know, I mean, not that we don't know people who might not roll the dice, but in real world, but you got to really think twice about, you know, going forward in a lawsuit where you theoretically just lost in the court you're going to end up, or a court very much like that. So something to think about. Again, if you want to take it to kind of an odd, I don't know, maybe you guys will, you know, become the ADR kings of the valley or something. People will come to you because you will have all sorts of answers that the average lawyer will not give you. But, you know, again,
Retired judges do.
yeah, I mean, and plus we have to keep them busy. Right? And so, you know, think about it, you know, or even have your little, you know, mock juries and things like that. Right? It just depends on the litigants that you have, but and the underlying matter. But a lot of times I personally think a lot of the things that I see go to court could pretty much much more easily be solved without that type of expense and loss of time and things of that nature. Again, that's just me. I mean, I was never a go to court guy, so I was always like, if we could settle, we should settle. Because it takes a long time. 2 years, you want to live with this, you want to see this guy, you want to think about that guy every day.
It's also a waste of everyone's money.
Well,
always make the correct business decision for your client.
it's.
I mean, don't make it for them, but advise them as to what would be the odds are the most financially secure way to advance their rights.
Well, as I used to always point out to some of the different people that I knew that did family law and divorces and things like that, and it's like, great, now you won the family fortune that they just gave to you. Good victory there.
Yeah.
Good for me.
On the other hand,
Not my fault they don't love each other anymore.
if everyone just got along, we wouldn't be sitting here right now, would we? We wouldn't be. So we gotta
Everybody
love
just
this-
signed a prenup from the get-go.
Yeah.
I would be taking half your fortune.
Can you get a declaratory judgment on a prenup? Because there's not a controversy if both sides are claiming that one document. There's not a controversy yet.
Oh, you can get a declaratory judgment on that. If you
On a
think
prenup?
there's a legitimate.
We have to challenge the validity of it. I mean, you can't both go in agreeing that it's good.
I think that's what I'm saying though. If
No, there has to be a controversy between validity, doesn't there? Like one party has to say it's valid, the other party has to say it's not valid. You can't just go to court and be like, here, will you rule this valid?
Well, there's no controversy.
Well, that's what I mean.
Right.
You
There has to be a
You have to
controversy.
have adversity.
Can you get so what if you don't, and you have a prenup, and you write it up, and everybody signs it, everybody agrees to it, everybody thinks that this is awesome,
Yeah.
and then before we get married, we want to make sure.
However, I will say this though, and it's funny because you're talking about family law now, right, and things in that area. And remember that family law is one of the few areas where you're allowed to have collaborative counsel, which means both parties are allowed to have one counsel. So as long as they both sign off, and as long as they both feel happy with
It
it.
is a bad idea. That's why everybody says that they don't do it.
Yeah.
I don't know. I don't know how it worked out. I hate that. Anyways, it almost worked out once. All right. So anyways, all right. Good job on that. So who wants to tell me about the Nashville, Chattanooga, and St. Louis Railway?
I'll do it. So this is a case where the state of Tennessee enacted a storage tax on all gasoline stored in the state. Nashville, Chattanooga, and St. Louis Railway Company, the plaintiff, seeks a declaratory judgment that this is unconstitutional based on the idea that it burdens interstate commerce. I guess they'd have to point to some. They ended up losing this argument, but they would have had to probably point to some federal law that says that this has been usurped, and they don't have that here. This is just a tax. But despite that, the question is the federal court allowed to issue a declaratory judgment? So here there is an actual controversy. You have a government, a state government, that is enacting a tax, and therefore they want their money, like they're going to try to enforce it. And you have a business who doesn't want to pay it, and they think it's unconstitutional. So there is a controversy. Can the federal court, I assume sitting in diversity here, because no, not diversity, federal question probably, right? Does it even specify?
Oh, it's a federal question.
Yeah, federal,
It's
but
federal
it's a
law.
state. It's a state law.
Oh,
It's a state tax.
the state tax. Though.
Yeah. No, the question is it constitutional? That's a
Yeah.
federal question.
That in and of itself.
Yeah, so it's a federal question. Whether or not the federal court can issue a declaratory judgment, they said yes. They may decide cases and controversies under Article 3, Section 2 of the Constitution. Advisory opinions are not permitted, but adjudication of rights must be made. Therefore, declaratory judgments may be informed, advisory, but they grant relief. The relief they grant is not merely advisory. The respective parts of the rights of the parties are in controversy, and the holding will decide the controversy. And then they, at the end, say that on the merits, the court upheld the tax. Like on in the little brackets there. So this tax ended up not, it's a state tax on stuff within their own state, and I don't see how it can be, how any tax can be so like. I mean, I don't even know what the federal issue is in interstate, in interstate commerce that would like trump the state's right to do this. To me, it seems like a weird argument by the corporations. But
remember that railroads are very unique. They've got an enormous amount of federal laws that protected them because they had to go west and they couldn't have the states stop them. So there's an enormous amount of laws that are really very particular to railroads that are still on the books.
okay,
And railroads are almost entirely run by federal law.
right.
So that's actually why.
Okay, I'm sure they had plenty of little knickknacks in there then.
Yeah, well, for sure. They would routinely kill an enormous amount of people. So federal protection. I hate to put it that way. But
Sounds like a plan.
Just give them immunity like everybody else.
Let me put it this way: no railroads, no contributory negligence. There would never been contributory negligence, not in 1,000 years. It was all for the railroads.
But wasn't the case we learned about foreseeability on a railroad case?
No, he's saying without railroads, we would have never had contributory negligence case law.
He's saying that contributory negligence would apply to railroads.
No, contributory negligence was
invented because of railroads, right?
Oh, okay.
You wouldn't
Yeah.
have the theory without railroads.
Right. So it was designed to protect the railroads from the railroads being negligent.
It protected the railroads because everyone's going to be at least, why didn't you get off the track? Out.
Right.
And that's the way it was. So very powerful, the railroads.
Because I was tied down by the evil villain in the black and white film, and I just couldn't get off.
You didn't have a knife. Out. TNT. Out.
Intentional tort, that takes us off of liability. So
Why were you-
that's
somebody
a
else-
superseding cause.
Somebody else put you on there.
Or as I once heard, why were you even in Missouri? You knew they had railroads there. Out. Okay. Okay, so we get the idea from this case, though, right? Again, interesting controversy, constitutional issue. What is a controversy? What is lots of interesting issues come out of these declaratory judgment cases, I think, anyway. It's just on that very basic jurisdictional level. What can and can't a court hear? So, if you think about it without, belaboring it, and you say declaratory judgment, wouldn't your first impression be how the court can't hear it? It's just an advisory opinion. How does the Supreme Court hear it? Now you know. It's a little more than that. So just because it's not enforceable doesn't mean it's not a controversy. It doesn't mean it doesn't have some effect on the individual rights.
Interestingly, it doesn't say that it's not enforceable. It says that just because no other, because the fact that no other relief is granted does not render the opinion merely advisory. So I would like to see a case that popped up, issue preclusion. Can this just have preclusive effect?
I vote it can.
It can, okay.
I think we get to those cases.
What are you going to do when you show it to the court and
It's-
say, look,
It's in the notes. The issue
yeah, it's
preclusion?
like, why are we relitigating? This court's already spoken on.
Right.
Yeah, so.
Okay.
I think you see a lot of, again, another interesting place you see declaratory judgments is in personal injury, believe it or not. And what they do is sometimes they go to court to figure out issues of control. Sometimes they go to figure out issues of liability. Sometimes they go to figure out some of the individual issues like, respondeat superior. They'll actually break out part of the case and say, can you hear this? And what would you think? I've actually heard PI guys doing that too, particularly with control, whether they were in control or not, because once they rule, it's kind of, right? You were in control. No, we weren't.
It could solve the whole case, much cheaper.
Yeah, I have heard of that. So them doing that and stuff like that. So, which again, repetitive. Unripe, but is even the threat of having a law imposed against you to the degree that you would lose, if it was imposed against you, you would lose, it would infringe on your rights, is that enough to be ripe? I mean, in other words, no one's made me pay this yet, but it looks like I'm gonna have to, and I think it's not constitutional. Therefore, it's
Basically, the threat makes it ripe.
everyone agree?
Like the threat, like if somebody tells you I'm going to sue you,
Right.
Yeah.
that kind of makes it ripe at that point.
Does everyone agree? Yes, no?
I do.
He's right, yes. That's
Because
right.
I know one of the notes said in some jurisdictions, as long as the law is on the book, then it's right.
Well, I think that's stuff.
And then in other jurisdictions, most jurisdictions, you have to be at least threatened with prosecution or suit or something in order for it to become right.
Right, by the time it's threat, that's it.
Under Steffel and Zoran, they kind of
Pretty
split
much.
that.
Yeah, that was one of the cases.
They like decide that one person actually got, never mind, we'll get to it.
That's it. I mean, see, there you go. All this stuff that you learned in common law, I thought you'd never use it again. Of course, you knew you had an agency,
Okay.
so you knew that.
The force and effect of a final judgment or decree.
Yeah, I mean, just because.
I would assume so.
I mean,
What's the
just
point
because there's a
otherwise?
law on the books, that's usually not enough. But once you're actually have done something or are being threatened, or could even be threatened theoretically, that probably is enough too. Even the threat of could, probably enough. But again, there's lots of laws on the books that we may think are yes or no, but what's the problem? Well, what, as a practical matter, boy, if any of you remember this, that would be amazing. As a practical matter, there's a lot of laws right now that I think are very unconstitutional, right? Some laws. But for most part,
You don't understand it because you
I'm
haven't
not
been
a proper
injured.
litigant, and I'm not a threat of being even, there's no imminent threat of
Yeah.
harm. I'm not in this industry or whatever else have you. And just because I think that's not the way to go, that doesn't make me the right litigant. So even if by some chance I get through justiciability, right, which is even sort of the court's jurisdiction, I'm gonna get kicked out anyways at the standing level, right?
And then once you do violate it, you kind of lose your ability to challenge the constitutionality of it anyways. Didn't we learn that last year? Like, you have to challenge it before you violate it if you, like, want a declaratory judgment or something like that. Otherwise, you lose your right to be able to challenge the validity of the statute or something like
Yeah,
that.
you can't just do it and then claim it's unconstitutional.
Yeah, you have to claim it's unconstitutional before you do it, right?
You do it. Yeah, you can't just go out there and say, I have a right to do this, and they let you go. It doesn't work out.
Unless it's void for vagueness, right? That's the only time where you can, like,
That's
challenge
your
it.
best shot. Yeah, that's your best shot. I had no idea that was violating the law. That might work, because that's a due process problem, so that might work. They might just say, well, mess with it.
Because I know, like, when we had the common law class, those were really the only cases where you got let out of the crime after the fact, right?
Which ones?
Void for vagueness.
Yeah, I mean.
Otherwise, they always said
Right.
you have to challenge it before you do it.
How are you standing before you do it?
Yeah, I mean, you can't claim that you think that a law is unconstitutional and then do it and think you're going home. Okay, that doesn't work that way. Possibly, though, the vagueness issues, you never were on notice that it applied to you. That's why that would kind of work as a notice problem then. So it falls more into due process, and then all of a sudden it's a mess, right? Now you've been denied your constitutional, probably First Amendment right, and you're violating due process. Right. You know, all because how many states do you think actually really artfully draw a lot of these statutes, right? Actually, it was funny because there was a case came across mine. That is not for me, of course, but I'm just saying I was looking at a case the other day, and it was a case in Arizona that a guy is doing something down there. I don't even remember, someone sent it to me just what I thought about it. And they had written the most crazy, unbelievably strange statute about signs. You know, again, one of those.
Like billboards.
Yeah, like, well, not even billboards, they're just, even just political signs and stuff. And I'm reading this, and it was giving you all the rules, and some of the rules were okay to follow, some of them, to follow those. But then it started to get into stuff like, of course, but if it has something to do with the church, it's fine. But then again, if it has something to do with blah, 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 it's not fine. And I'm reading that, and then all of a sudden they're using words like, and of course, unless it's, offensive to the average cowboy. I'm not quite that bad, but close. And I'm just like, I consider myself a fairly intelligent person sometimes, and I don't know what the hell these guys are talking about. I would have absolutely, positively no idea whether any political sign you put up there, because the best that I can see is that the sheriff don't like it, don't put it up. Now that's not a very good standard, is it?
That's
Hard
standard.
to say what exactly they're going to like and what they're not. But I was just really amazed at this.
And we're going to apply in these here parts.
Yeah.
And this is not old. This is going on right now. This is not an old case, what they're going through. And, you heard a lot of this stuff back in the 50s, to be sure, but I was just, wow. And the funny part was like, well, why don't you just read the Vincent case? We did. And you actually kind of know you can't do that anyways, because it's, none of you would remember this, but you've broken off categories anyway, so it's going to be a facial violation of the stand. Statute you can't stand. Okay, you've broken off categories, therefore it's content laden, right? Content laden, strict scrutiny. How are you going to argue? I can't say this, I can't say that, particularly in a political arena.
Yeah.
I should have just written that. Go for aesthetics, just ban them all. That might work. But truly an amazing statute, and again, it was pretty big. Anyways, I think it is time for a break. Yep, take 15, come back and then we'll just get through the last of the cases. Yeah, we don't have too many tonight, but I'm gonna take a break. I had a long weekend, pandering to the masses.
All that partying with the open bar.
Very hard. Remind me of that. Can't drink. Open bar was useless to me. Useless.
You guys are still hanging in there, huh?
Yes, sir.
That's good.
How are you, Warren?
Pretty good to see you. I'm not trying to subvert the school.
What I read so far sounds fine to me.
Oh, no,
These are very legitimate
I have strong
questions.
feelings, and I went through this process. Okay, I mean, that's how I went to school. I went to a non-accredited night law school, so I know, what's going on. What we did at that school is very successful. And I'm just, I only want to help. Okay.
Well, yeah. I think that, this is good. I mean, a school that never examines itself is
No, and
always
we-
going to be in trouble anyway.
If you keep doing the same thing, expect a different result, you're crazy.
Mm.
So the first year was very special because it was brand new and everyone was excited and we were all reading the cases and I think the students could feel that.
Mm.
But then the second year, now all of a sudden, people were teaching two classes and we're starting to get stretched out, and then all of a sudden we're doing multi-states and then the exams, and then after the third year, I mean, we really start spreading ourselves out too thin. And I think it's you teaching here by yourself. I'm not really a big advocate. I like teaching the Sam Trust basic fantastic, but sometimes I'm thinking that it's just sort of too much.
Mm.
So the first year I taught Dave Chapman, Judge Chapman, and I taught 3, and then he taught 3, and I taught 3, and he had taught 3, and then I taught 3. Then of course, that's not what we had in mind. So, but we don't get burned out either, or something like that. Or we get his style and mine are fairly similar, and I think my teaching style is very similar to John's style. But so I proposed a long time ago when Sheila Williams was here. Let's form a committee. Let's get a little foot taking. Let's come up with some ideas around it. So it's never happened. So then I finally tried reading. So anyway, I'm only here. I'm not here.
Well, let me ask you a question. And again, I will not do anything.
I don't want to undercut is what I'm saying. So
Oh, man, I don't think about that, honestly. Honestly, really don't. But here's the deal is I remember when this was all coming together. If I try to bring the group together, will you all come?
You don't know, the think tank?
Yeah.
Absolutely, yeah,
Okay.
I will.
Okay, well then we're just gonna,
I mean, I don't wanna do it on the weekend because I go to the beach every weekend.
oh yeah, you know, we'll pick
Other
a
than
place,
that.
but I mean, if I can get a small group of people.
I'm
willing to do
happy
it,
to
let's do
participate
it.
with an open mind. Yeah, because I think I'm a very practical person in that regard, very practical.
Okay,
So
let's do it.
Trussell's the professor. I'm the nuts and bolts guy. You know, what do you need to know to get in and get out, get a 70? So that's why I think we make a pretty good match. But I would be more than happy to do that, to sit down 3 or 4 hours one day down here at the school, or if you want to get a place outside of the school.
Yeah, I mean, let's just start an action committee.
Yeah.
And what it'll do is it'll meet as necessary, but we can't.
Hopefully you have the framework.
Yeah, and now we've got a framework to work on.
Yeah.
Okay, let me work on that.
Okay.
I'll put something
But
together.
yes, you can.
And I'll be there and I know
I
you'll be there.
will do that.
Okay.
Okay.
Just gotta get a couple more people though. Whew.
Yeah, exactly. They think like, okay, like we're basically just gonna keep the show on the road. We're gonna keep ourselves.
Yeah.
You know, we're
It can't revert away. I mean, it is astounding.
I also find it interesting how corporations had it where shareholders or the partners in the organization had 100% liability, and not just where like you basically have corporate fail and actually sue individually.
Yeah.
It really is
Got it?
not like that.
I'm checking my messages. I'm checking my 1,742 unread messages. That was today. Wouldn't that be fun? No. Pressing. Think about that. Easy, huh? Yes, that's who you are.
Okay, slow down. Right. Okay? Yeah. Okay. Straight out of the, okay, come on, sir.
Yeah.
Discuss the ways to make things better, and, you know, and also it could theoretically lead to increase in knowledge.
Well, and one of my ideas that I sit down with is, most people that send to discovery and see their law, they should have time just learn it, sort of on their own. And I think they help with retention. I think one of the problems is that just like students, they just feel like every single it's too much. Well, maybe not even everyone, but twice during the session, people decided themselves,
Well, I once proposed meeting the fourth year Saturday.
Okay, well, that,
So we're thinking on the same lines.
okay, but.
So you're just being nicer to more people, I was being nicer.
Then this is for them to try
I guess you might say.
try to study on their own. It's just have kind of that like relief, like I know that I can.
People know how to study them.
Well,
And
that's,
also
but that's why
there's-
he's saying he has it, because they're not gonna say on time, but I think.
Not true.
Right.
And also they need reflection time.
That's what I'm saying, and the fact that they're doing it every day of the week, they need to have that one day where they can just say, you know, Saturday, I'm just gonna hunker down. Because by Sunday, then they're exhausted, and they don't do anything on Sunday then. You're gonna start and run. I just think that would help with retention, I think that's our problem, that's part of our problem, is keeping students here. Anyway, food for thought.
So you're in. So if I convene a panel, so
I'm
to
in.
speak, if I like let me think of the name, what you would call this group. So you're in?
I'm
Okay,
ready.
I'm in, John's in for sure, and then you're in.
Oh, I have like a ton of that. I didn't even read this whole thing, but I have a ton of little things like
Okay,
that.
so we just need a note taker? Yes, no.
Sure, I'll trade off with the.
I mean, if not,
Yeah, yeah,
I
yeah.
I mean, I just don't want to do it.
No, no, I used to do that all the way.
I do it if I have to, but my notes are horrible.
And then the other thing that students ask me to do is, you know, I come in on Saturdays, rather than just throwing it to them, they wanted me, they gave me a whole list, and I was gonna do it, but I didn't realize we had to say, really, Saturday. It's just over like very specific things in different, like property, what they want to go over. Just different issues within property, or different issues within hearsay, because they really need more exposure to that, and they want to just kind of talk about it, and it's like, and that makes sense, because when we get to a question, and they have all these questions, I was like, we could spend a whole class talking about, you know, remainder and all of that stuff, but they're like, they just really want to talk about it the whole class. So I think that's, and I would like to use Saturdays as like a 2-hour jam session on different topics, like they can do the.
I mean, I would think that would be really interesting, but I would have to think the students would have to be involved though. They would have to understand that they would have to bring so many issues.
Oh, and they did. So like this group did it with me. They said they got together and they said, well, if you guys want that, I said, if you guys want that, because they said to me, we don't really still understand this particular thing. And I said, well, if you guys want that, write up a list of what kind of like what's your priority things you want to do.
Well, so you would
And
make
I'll be
it a,
prepared to talk about those things.
so you would make it a weekly hotspot issue.
Right.
During the week, we wanted to know more about this.
Right.
I didn't quite understand that.
Right.
Put it up.
Right, and then I would give them kind of these real kind of practical examples of things, or, you know, and also like I found some, like, there was one thing I found some like silly video on that really helped explain it, and they were like, oh, I mean, you know, I can really get perpetuity, so that crap.
Okay, like the good old, it's
funny, that's why you see the COD. It's got that little videos for them.
Right, and so, you know, would be on me to kind of find something, I mean, not saying a whole class, but one little thing, kind of, give them a perspective. Sometimes it's like, that's the life of it. They've heard it 15 times. Anyway, that's kind of some of my thoughts. So I just want to start doing that on a limited basis, but
Interesting. Because I mean, yeah, the Saturday classes are,
yeah.
they're interesting, but they haven't quite reached their potential. Really,
Yeah.
They negotiate with the pros this week.
Well, it-
Negotiate
it's
with the
not
pros.
and
I am going.
responsive.
Not
That's
going.
what you
No.
said was
You
curious.
guys emailed them.
What?
It has to
Just
be
got emails
responsive.
about
It can't just be,
I didn't.
March 30.
I mean, they're not.
I probably deleted
You
that.
can't just.
The one that we got today? Oh, there it is. At 10:50 a.m.
It says they can do that. Maybe.
Your product comes in. Does it keep having RSV sheet yet? I go,
Right, so.
because I'm not going.
This is one of the optional ones if I've done it 6
I
times.
think one of the
No, it still counts, but I know that I've done it 4 times now. I'm not doing it again.
I don't see the value in keeping it. That's just-
Okay, now there's 2 other ground rules though, which I will explain. I mean, I actually have done this across the entire. I've done this.
Oh, 13 hours. that you do?
Well, I don't care about that, but there's 2 other things I just, want to be clear, and I'm not worried about you, Judge Evans, right? But there's 2 things I don't want. And I don't do it. Concept in this one, it's not a big section. If you're not interested, you want to make things better.
Oh, right.
That's fine.
Right.
And see, I want to
Oh, that's awesome.
No, I mean, I don't want to invite students.
Oh, right, right, well, that's what I kind of, right. But no,
It's nothing personal.
oh, I
It
agree.
is.
I just saw it as a way of, again, with attention, and I don't think that students should be down the line, like to be at one.
All right, so let's say this.
As
then.
opposed to.
Okay, so the goal then,
Okay.
I mean, because again, the bottom line is merely saying something like learning, that's the slope. Okay, the question becomes, we have to, I think, focus on 3 groups. And again, this is a great list, but how does that relate to retention? Okay, I mean, everyone wants to get better, but then how does that work in your retention?
Right,
Okay,
right.
Number 2. Okay,
That's good. I'm with you.
okay, well, how does it,
This is very Deanish, I'm aware.
Yeah, this is like when you're a professor, you think every professor is so smart. This is when you're a dean, you think every professor is an idiot. And the reason I'm so good is because I'm
Well, and
so I get to be.
And I worked at an institution for over a decade, so I know that they have one way, and then they would come in and we would all say this and be like, nope, we're not doing
Oh,
that.
I thought professors always knew the answers because they were in the classrooms until I became dean.
They have a whole.
No, within 48
Right.
hours, I thought professors were.
And so,
completely
and so
lost.
I have an understanding of this when I talk to people on the phone. And I tell them kind of, that type of thing, like, it's all vague. They're like,
Okay, so retention and enrollment, how will this help our
right,
enrollment numbers? Because it should.
Right.
I mean,
Right.
that makes perfectly good business to me. And then number 3 would just be academics.
right, how
And the
does
reason
impact?
how really does tell me how this impacts
Right.
academics, which of course, the problem with this is retention is just like, there's always a number. Okay, how many graduate? That's easy enough.
Right.
Enrollment, okay,
right.
is it up or is it down? I mean, it's
Right.
pretty simple.
Right,
And with academics is like, are the grades going up? So we always have 3 ways to check these things later.
right. But I think the fact that, we lost half of that. That's a lot.
I mean, and again, but this will be the key though. And I know it's sort of funny, but these are all very good ideas, but tell me why this will get better. And if you put the link in there, it becomes very compelling.
Right.
If you can't, it sounds like you're guessing.
Right.
It's like, well, okay, maybe we can do that, and maybe someone will be happy and someone won't be as happy, but why is that going to translate to this?
Right. And all of mine is just, I don't have
It's just something to think about.
statistical
that's all.
evidence, it's more, anecdotal, or just,
Well, we don't have any right now.
or, a feeling, and obviously,
Yeah, but it could even be when I worked here,
oh, right, oh, yeah,
That's
and we did certain things
we
to
found this too.
improve, and obviously, on a personal level, I don't care, right? I just wanted to get better. Like, this is not about me, I don't care. You know what I mean, like, on a personal level.
So do you think you can haul someone in?
What?
Oh, get someone in the group. I mean, I'm happy to meet, but I don't, let's get 4 or 5 people.
Oh, for that, yeah, I just work for it.
No, you're in the group now. You're
Do we get
committed.
t-shirts and hats? Yeah.
That I can do, I think.
Well, keep me
Let's
posted.
just think about it though.
Yeah,
If there's
yeah,
somebody
yeah.
that you think should be in this group,
Oh,
let's try
yeah,
to
yeah,
bring them in. And
Well-
we're not asking them to commit for,
Sue, I think.
so it would be good.
I
She'd
mean, I
probably be willing
think,
to do it.
she's very practical and reasonable and wants to kind of hear the big picture. And I think she's often open to trying something new.
Yeah, I think so. I don't know why
I
she would
think
be.
this is working really well, but I think we could always improve things and, and it could be working even better. I think we know that.
Well, and we have to.
Right,
So, I mean, there's not, we have to.
Right.
That's what we do. So, okay, I'm down.
So,
I like it. I like your enthusiasm.
Yeah.
It's making, and your enthusiasm, his enthusiasm are making me enthusiastic.
I mean, and
That's
again,
kind of how
that's
it
what I was trying to
works.
say, it's not like me personally, it's like it all comes from a good place, like
Yeah.
and my initial thought may be wrong, but maybe if we massage it a little differently this way, then it would be better or something like that, but I mean, those are just my initial thoughts, but I'm sure if we kind of brainstorm, like you said, that people may say, well, maybe do that, but let's tweak it and do this, and then I'll be like, oh my God, that's, you know what I mean, so I think we're there. All right, well, if they're all entertained.
Yeah, that's fine.
Sounds like you guys have a plan. I don't know what's going on at all.
We're doing something, we are robbing that bank at 2:00 on Saturday.
I can
That's
do
the
it.
plan.
I can
We're on,
do it.
we're on camera.
I'm in. Write me down.
All right, you're in.
Thanks, CJ. See, it's exciting to have excited people around you. That's
CJ
the
is
way it
down.
works. Yeah. People who see their lives as drudgery, and, well, that's what you do, I guess, but, see, she's an educator. That's what I like about her. Boy, all 3 of you at once. Modern world, I tell you. Let me so what are your email addresses, or let me send you a text, maybe that'll be easier. Hey, class is starting.
Not sure if I text.
We were just joking around, so the other day, it's like, well, just text him, he's like, he's sitting right there. Just text him, it's quicker. Okay. Hey, you. Okay, so, off and running, yeah, we're doing good? Okay, let's get through these cases, let's blast through, yeah? Again, the better that you read, the better I am happy to move on. If we get what we get, we move on, right? We're not gonna keep beating the memory horse, okay? We've got it. Okay, who can give me Cardinal Chemical Company versus Morton?
So, basically, Morton owned 2 patents, and then there was a couple
Okay,
different organizations that had sued them. They had sued based on patent infringement, and they filed a countersuit for a declaratory judgment that the patents were actually invalid, and therefore there was no patent violation. There was the Louisiana case that was tried first. The judgment was that there was no infringement because the patent was invalid. And then it went to, and then there was a second case that ruled the same way, and then the Delaware case was still going on. There was a South Carolina case too that ruled the same way as Louisiana did. So Morton appealed, and I guess there was basically like a per se rule where the federal circuit courts were declaring that if the patent was found to be invalid, that the infringement part became, if there was a finding of non-infringement, then the validity of the patent was automatically moved. It didn't even matter anymore. And this case basically said that no, there's a lot of issues that can still go on, whether or not a patent is valid or invalid, including future uses of the patent by both the infringing company and the creating company, and they want to be able to protect themselves. So the court said that this Federal Circuit's practice, it's not a valid practice and is unconstitutional. Therefore, they said that it could go back and be heard. I mean,
Okay.
there wasn't much else in that case.
Yeah, I mean, it's not a terribly complicated case. But, yeah, that's pretty good. But notice this part here. This is interesting, 598. I just want to point this out. Because, in particular when it comes to intellectual property, patents are, I don't know exactly how to put it, pretty interesting. And some of the techniques that companies use in patents are pretty weird. And there's just a lot of business stuff that goes on. A lot of times what happens is just so you know, I mean, you might find this fascinating, you might find it horrifying. But when a new invention, and actually Will would probably appreciate this because he's a capitalist guy, is a lot of times when a company will invent something new, what they also do is they patent not just that generation, but they patent the next generation and they patent the next generation. So in other words, they know where the technology is going. They just don't want anyone else to come out with it while they have the original patent. So technically, big companies like Apple, as powerful as they are and as good things as they do, don't get me wrong, they also have their ways of making sure that nobody interrupts their business cycle. This is very, very, very common. Just so you know, this is not me making this up out of the blue. How much effect that really has on society, we don't really know. But it does have a, it is kind of, it's legal, but it's kind of competitive, if you think about it, right? So those kind of things do go on. There's also persons called, it's funny because now when you say troll hunter, you're probably thinking about someone that goes online or something. But the troll hunters that we used to know back when I was doing intellectual property was there were these guys who would do nothing but look through the patent rolls and stuff like that, not for patents that had expired, but for patents that were still good, but nobody was enforcing them. And then they try to figure out whether in fact this patent that wasn't being enforced was actually in another patent somewhere that somebody else had patented later after that time. And they offer to buy the patent, and invariably that's when they would hold the patent over their head. And they say, well, here we have this patent here, which we think you're infringing on it.
And have they permitted that kind of tactic?
Oh, you can do that.
Because
That's legal. That's totally legal.
that's
People
totally
do
messed
that
up.
all the
But
time.
they have they're not furthering the patent, the original patent in any way, right?
No, you're freezing confusion because I was like troll hunters. Because I know what a troll is. I know what a patent troll is, but I thought troll hunter was someone that goes after the guy that does that.
Yeah, but that's right. We call them
like,
patent
oh,
trolls and things like that, or troll hunters, because they'd be hunting,
Okay.
unused patents. But I find it really funny because notice that one of the reasons why they make the argument that declaratory judgments, particularly, in the intellectual property arena, and particularly in patents, is because of notice the indented part there in the middle of part 3. If anyone who didn't read that, you should read that because that's actually really what they're talking about. They're talking about these they call them a lot of different names and things of that nature. But this is what they were talking about is, sort of holding, dance macabre, and then they give you this whole thing in the bottom, which I think is completely cool. Dance Macabre is just an old song by Sam Sound. For those of you that are fans, it's kind of cool. But anyways, but they talk about the sword of Damocles, right? You probably heard about that, making it down an easy decision, which is, what should I do if I do the wrong thing? This sword is hanging over my head and it's going to, obviously cut me into two pieces. And then they talk about being in terrorem, which again is another word for just terror, like threatening suits. So again, we even talked about that today, right? I mean, I don't personally think at this moment that a declaratory judgment will really help Michael Avenatti, but who knows? That kind of thing, right? But notice that really here it is, they're talking about being sort of stuck in this limbo while someone's threatening to you, and there's really nothing you can do to them because you don't know. It's like they claim that they have a patent that we're infringing on, but isn't it true that you really never know until someone litigates it? I mean, how would you know? And so when you think of it that way, I mean, and you're trying to make these business plans, right?
Mm-hmm.
Okay, so you're going to put how many billions of dollars on the line because you might get this, and then you might get hit with this massive lawsuit and lose? Because remember, in intellectual property, as we discussed earlier too, remember that the damages are very unique. I can get my lost profits, I can get my damages, and I can get your profits. I could be doing all this for nothing. I could be losing my shirt for nothing because there's this guy out there who bought a patent that he thinks, right? And even if I put my guys on it, who cares, right? Who cares? Because they could be right and they could be wrong. Doesn't matter. What matters is what a judge thinks, not what I think, or not what my engineer thinks, or not what, of course, if they say, oh yeah, we're definitely infringing, you might consider that. But the truth is, particularly in intellectual property, you never know if you're really infringing on anyone until a judge tells you you are. You never know until that. You can't know. And you never know what they're going to say. I guarantee you what they're going to say. That's one of the weird things. It's like, I'm not going to name names or anything, but I've been in front of judges and I would swear they need glasses. And if you're in music, guess what? They're all tone deaf. I mean, they will say things and write things and you're sitting there and you're just like, you've got to be kidding me. Do you need hearing aids? I almost want to be yelled at the judge. Of course, I'd be in jail for a couple of days for that one, but I'm sitting in the courtroom just going, oh God.
What if someone like me who honestly believes they're tone deaf, I've never had musical skill, just naturally, I suck at it. And what if somebody came before me, could I be like, honestly, you need to go to another judge? Could I tell, can we come to some kind of conclusion that you need a judge that can understand music?
Well, you don't. I mean, you may not.
I would have sympathy for a statement like that if it was directed towards me. I'd be like, all right.
But I'm talking about the level of, let me do it this way. I'm not saying that the law is good and the law is bad. But look, does Ice Ice Baby infringe on Under Pressure?
Probably.
Yes.
Yeah.
I've had situations where judges have said, I don't even see the comparison. That's going too far. What do you mean you don't even see the comparison? And I actually had one judge too one time who said, and this again is not a tone deaf thing, but it's just really interesting. I thought we had, I don't know, KKs. It was a rock and roll type of thing. And he said, basically, well, I can't really rule for your side because all rock and roll songs are the same. They're all the same. Every last song that's ever been written. Why don't we just give all the money to Chuck Berry and go home? Because you don't know. I didn't say that either.
I'm sure Chuck Berry would appreciate it.
Yeah. Is it state or whatever?
He probably would have. I guess he's dead now. Oh well. Anyway, and at that point too, it's and while you're at it, that thing called funk, just give it all James Brown. Nobody's ever actually really invented anything that didn't rely on his sound, so may as well just go there with that one. Let him fight it out with, Sly Stone and see where we go. Okay, so we good? Again, not a hard case, but again, very interesting in the patent milieu because it's very unique, very interesting patents. They're really not like anything else. Since none of you are engineers or chemical people, you won't probably be patents. But strangely enough, you might run into a day where you're more than welcome to write licenses and stuff like that. I did that all the time. You can write licenses and contracts for patents. You just can't really get any patent court. And I wouldn't try to do that paperwork. You're probably asking for it. So, but you can do it. It's legal.
Did you get yourself on the patent bar?
If you take the patent bar, the only thing it allows you to do is practice in a patent court.
Did you do that or no?
Oh no, you have to either be an engineer or a chemical.
Right, it's a STEM
I have
degree.
one, so they won't let you take it otherwise. So, but that's the only thing you can't do. It's not like you can't write a contract for a patent. People to do something. It's not like you can't write a license. It's not like you can't. You can do all that stuff. I mean, you can even take a stab at doing the paperwork if you want. But I as an attorney who would not get rid of the patent bar, I would super recommend that. So, because they can be very technical, and you're more likely than not to get the drawing wrong. That'll set you back forever. So, not a good idea. On the other hand, you could always just hire an engineer. Of course, you won't know whether he's doing it right or not. So,
Very true.
but I would just stay away from that. I always did. I just would tell people, well, if they already have the patent, I can help you with anything before I do it. Because I can't help you. Yeah, okay. Moving forward, okay, any other questions about declaratory judgments? Again, I would not poo-poo them, that's all I'll say. I've had many lawyers who come around, and I think they can be interesting, I really do. I think they can, you got the right client, be all right. So let's go on to something like interfering with state enforcement proceedings. How's that sound? Who wants to do Steppel versus Thompson?
So this case kind of goes back to what we're talking about, where the threat of the launch. So we have here, we have Stifel and Becker. They're handing out anti-war leaflets in a place they don't want them handing out anti-war leaflets. And we have a police officer coming by and saying, "I'll do that, we'll arrest you." But Stifel takes a hint, Becker doesn't, he goes hands out leaflets and gets arrested and prosecuted. And
That never happens,
never
That always happens.
so now they're trying to ask the court to put an injunction on prosecuting for criminal trespass and saying, well, don't do it, just hold off until we get this federal constitutional law done first, and then we can go back to this one. The first he denied it, saying, well, it's not right without a prosecution. But, the higher courts eventually said, well, the threat of prosecution, does ripen a constitutional issue.
Okay, so the threat does work for ripening the constitutional issue if you're talking about civil rights, right? Okay, good, that's true, actually. Again, we have a case here, though, where one person was arrested and one was not. The one who's not.
One wasn't the one that went through.
Right, he's the one who wants to do it. I mean, you might, at first glance, you would think that he would not be the proper litigant. He wouldn't have standing. But if the case is right for review, what are the chances that, in other words, what I'm saying is it also translates that isn't just the threat of litigation to a infringement of a right that seems to be enough if you're dealing with civil rights.
Also, had he violated the statute and got prosecuted, he would have lost his standing anyway. Right?
Probably would have lost. Yeah, I mean, well, he did it. So again, he is subject to that law, even though nobody arrested him. So that's enough. They're saying here it's right? It's like close enough. You don't have to actually be arrested. Now, of course, and all I'm saying is that, and yes, that translates over to standing as well. Okay, so imminent threat it's more like imminent threat really, but when you get to civil rights, they push it up.
So would Becker still have that standing even though he actually got arrested? Possibly?
Well, he actually would, for sure.
Okay.
But we're talking about the guy who didn't. But interestingly enough, right, he still has, he has a harm. So in other words, jurisdiction will be there. You know, it's close enough that the case is right. Again, if you remember back from con law was outlining, you know, you go through rightness, you go through mootness, you go through. Okay, so you guys got that? Again, kind of an interesting case because it's in the civil rights milieu, right? Otherwise, it didn't, I don't know. Anyways. Okay. Moving forward. Oh yeah, I love this case. This is a good case, you guys gotta admit. Duran versus Salem Inn. Hilarious. Who wants to do this one?
I'll do it.
Okay.
So I actually wish I had the underlying rule from Younger, but I don't.
Would be helpful.
Would be very helpful, but I'm gonna do this anyways.
Okay.
So I'm gonna skip the year because it's all the same year. On August 9th, these three, so we have rule is passed banning topless bars or topless establishments. There's three of them in this district that are going to, that on August 9th ask for TROs, preliminary injunctions, declaratory relief against, they named Duran, who's a law enforcement official. The next day, on August 10th, one of the three opens up shop again. And for the next like 4 days in a row, they go that day, and the next 3 days, they get served with criminal summons and break the law while their case is in court. And so under that analysis, that one person would have been barred under the Younger analysis. The other two would not have been. So the idea is that should the preliminary injunction stand for all three or just two of the three? And originally the lower court joined all the cases into one for judicial economy and to get one clear-cut rule. While under the Younger analysis, one of these guys would not have been, the M&L, the one that violated the rule, would not have been able to get their preliminary injunction at that point because they broke the law before the rule was determined. And the court held that a state party cannot evade the restrictions on federal injunction against state actors by joining parties not affected. So basically, you can't break the law and say, well, I should also be able to survive a preliminary injunction because these other guys do too. So in the end, the court split the two cases and decided that it didn't matter. Judicial efficiency was not more important in this instance, and permitted the preliminary injunctions regarding the two plaintiffs that didn't break the law, and the Younger analysis, which we don't have, would bar the preliminary injunction for the topless establishment that did break the law.
Okay.
Fair enough?
Yeah, it's pretty close.
Okay.
They do actually have quite a bit of the Younger rules here in note number 1 on
Okay.
619. And also, very interestingly enough, there's also a big part on it too on page 611 where they talk about irreparable injury, preserving preventive remedies, and 3 and 4 is the Younger doctrine and the Younger extension sections. So you pretty much get it all.
Okay.
Yeah, just so you know.
Yeah, sorry about that.
I mean, and the basic rule you probably remember is that it's someone from another state can't blah, blah, blah. What they're arguing about is injunctive relief, though, because remember, under Younger, mostly it's just injunctive relief that a federal court can grant. Injunctive relief, although money is different. So that's what they're kind of arguing in that case. Okay, just so you know. So it seems that they can. That's what I think the Younger argument is in that one. But interesting, I love that case for several reasons, but mostly it's because, like I said, in common law, everything eventually leads to nude dancing. Nobody believes me, but I'm true. Notice that at the end too, they do make the comparison. There may be a First Amendment problem because the courts have ruled that even in nude dancing, there is some aspect of expression. And so again, kind of weighs on the side of letting them be open, right? Because, if you're looking at success on the merits, again, do you have a whole lot of, expressive protection for nude dancing? And the answer is no. But do you have some? And the answer is yes, right? There's something there. So again, the issue seems to be a bit bigger. It does seem like kind of odd. I mean, you've got competing, businesses, and one, they're all threatened to the same suits. They're all doing the same things. One complies and one doesn't. The one that doesn't goes and gets an injunction. Now, can they do that? This case tells us no. Doesn't seem like it. Yeah, so pretty interesting case, isn't it? I think anyway. It's again kind of constitutional in its kind of scope and interest to me. Anyways, but okay, but it's not bad. I mean, you definitely got basically the right idea. Okay, so that's their opinion. There we go. Okay, unless anyone wants to know more about that, I doubt it. Thanks. Okay, so quiet title and the like. Who can tell me, just out of curiosity, why is this kind of unusual for a quiet title case?
Because it's not property, it's
not
personal property.
Okay, good job. That's why this is an unusual case and why it's in this section of the book.
It's a business, right? It's not even really personal property.
It's stock option, it's stock.
It's stock, yeah. So stock generally is analogized to money in the real world. Money is generally analogized to personal property. So that's how we kind of fit here. So who wants to tell me about Newman machine versus Newman?
I don't want to, but so Mr. Newman owned a ton of stock in the court in Newman Machine Co. He owned 64.77% of all the issued stock. Ultimately, he ended up transferring 11.477% of his shares into a trust for his children. He ultimately sold to the corporation all of his stock, which he sold for $135.25, and he in total got $785,802.50. He later sent a letter stating that he believed that the stock was undervalued and he wanted to look at their audit reports and books to determine if that was the case. Ultimately, his attorneys audited the reports and found that he had been grossly underpaid for his stock options for what they were worth, and threatened to sue them, stating that they had underpurchased the stock options and he wanted either damages in the amount that they were worth or he wanted it back, and kept telling them, you have bad title to the stock that I've given back to you, you don't own it, yada, yada, yada. Ultimately, the company brought an action for a declaratory judgment stating that they wanted quiet title on the stock, stating that they had good ownership of the stocks. At least the ones that were for the kids, because that's who he had an obligation to sue under.
He was the trustee.
Yeah, because he was trustee. So ultimately, Mr. Newman filed a demur to the pleading for a declaratory judgment, and the demur was overruled, and the Court of Appeals reversed the overruling of the demur. And the the Supreme Court of North Carolina, or Court of Appeal of North Carolina, whichever, basically stated that a demur is really not the way to answer a declaratory judgment pleading. because they said even if there is a something in the pleadings that state that a demurrer shouldn't work, that a demurrer should work, that should just be raised as a defense, and that all a demurrer states is that there's no cause of action, and there is when it comes to for a declaratory judgment. And then they asked whether you could even bring a cause of action for quiet title to personal property. And they said here, the only statutes that are on the books deal with real property, which was North Carolina General Statute Section 41-10, that said an action may be brought by any person against another who claims an estate or interest in real property adverse to him for the purpose of determining such adverse claims. And they said there is no statute regarding it when it comes to personal property. So we're just going to go ahead and apply the equitable statute that applies to real property to personal property, because property is property according to court. And they said that here they could bring a claim for quiet title to personal property in court of equity.
Okay, so in essence, really, what this case tells you is that quiet title is an equitable remedy in essence. And so you don't need a declaratory judgment because it won't do anything for you, because if you try to quiet the title, you either have it or you won't. So in this case, they're saying that the declaratory judgment won't help. And basically, but on the other hand, it wasn't a horrible idea, because at the time, if you read the statute, it may seem, in fact, that he couldn't bring an action to quiet title because it was personal property, right? And so, but North Carolina says, that's just old school, heck with that. That's when the courts were separate and everything. Let's move forward. Let's come into the 20th century, or in the 20th century, or whatever they're thinking, right? So that's pretty much what it said. So what do we learn? North Carolina, you can quiet title for personal property. Bless you. And that at least in this case, you can kind of see the declaratory judgment didn't seem like the proper remedy, because it really wouldn't fix anything under the circumstances. It looked like it's a funny case, is what I'm trying to say, because it looks like it might have been his only shot at law, but the court just said, just bring in equity in the drawing. So again, not the worst thing. I mean, all he has to do is just bring the suit. So, and again, the statute did clearly was not clear on that, but now we know. There you go. Okay, so not bad. Pretty good. I have no complaints so far. Oh, I love this case. We gotta love this one. Everybody loves this one. Who wants to do Hand versus Dayton? And do me a favor, okay, swear upon all that is holy, good, and worth having in this planet. You will never be as stupid as this idiot. Okay, this is complete stupidity.
You know what? You have a duty to read your contracts before you sign them.
Put your hand in this book.
There is no way that it could look exactly the same by adding in almost 10 words.
Please never do this. You
So,
will get so killed.
you know what? Dayton Hudson was trying to do something shady, and Hand was just shadier.
Does anyone, by the way, know who Dayton Hudson are? They're the family that owns, anyone know?
Oh, Carter?
Yeah.
I know.
I actually knew a Dayton. She was married to a friend of mine. And I said, "You still work?" And she gave me the stare of the century.
What's that mean?
So anyways, I think she wanted her husband to work. She was hilarious. Anyways, I said, "What are you working for, man? It's time to get your pimp on." She didn't like me. Okay, go ahead, please.
So we have here Dayton Hudson. They hired this gentleman and said, we paid $38,000 to give up any claims you could have against us. And Hand went and got the same contract that was handed to him and modified it using the same typewriter, and just said, "Oh, I give up any claim except being fired for age discrimination and breach of contract."
Mm-hmm.
they hand it back, everyone signs it. This Dayton Hudson doesn't know he changed it. So, eventually he gets fired. Now he's suing for breach of contract and age discrimination. And, the courts found, well, you changed the contract, and even though they signed it, and they had a duty to read and everything, your intentions were to mislead them and to give them the wrong contract, having them think they're signing the ones they gave you, telling them you made any changes. So we're going to rule against you for misbehaving and getting contracts and committing fraud and inducing them to sign all this such stuff. They don't get it.
Let me just read this part, then I'll feel good, because whatever happens in the world, I read it out loud. Okay? Bottom of 631. Check. Just really, don't do this. Okay? It's in an affidavit. And in his affidavit stated that he prepared the release knowingly and deliberately, and that he intended to turn the tables on Dayton Hudson, the evil Dayton Hudson, and committed fraud by not informing Dayton Hudson of the changes he made in the release. The defendant was excused from not having read the new document because the general rule of being held responsible for contracts that one signs, true, even if one has not read them, is not applicable when the neglect to read is not due to carelessness alone, but was induced by some stratagem, trick, or artifice on the part of one seeking to enforce the contract. The failure to read most definitely resulted from Hans' clever scheme, and accordingly does not bar Dayton Hudson from challenging the validity of the fight.
There's one of those urban legend cases where a guy did that with his bank statement saying the bank will pay me $100,000 and he just kind of modified the document and had the bank sign it.
There's lots of stories about stuff.
I don't think I agree with it.
There's lots of stories about writing things and lines on checks like paid in full or or making zeros and say that would mean most of it. There's this meaning of lines thing. Oh well, I forgot about that. Okay, fraud vitiates consent, right? First year stuff. The fact that he's a lawyer and did this actually made it way worse. And I want to remind you also that in these days, remember that this was not a computer he was using. This was a typewriter. A typewriter. Okay, so if you're going to make the two look the same, right, you actually have to work at it. It's typewritten. He had to type the entire thing over again. And there was evidence in the case where he had to keep kind of doing some of the pages because he didn't want them to be different, at the edges and things like that. So in case he looked. And even if you do by some chance do it, first of all, I don't want to know about it. But if you do it, don't put it in an affidavit. Okay, that's really crazy.
You can change the terms. I just have to highlight it and give notice. Or like, I changed it.
Yeah. Okay, let's not do that. That's like Michael Avenatti, clever. But at least in Michael's favor, it was 20 mil on the line. You gotta give him a little credit for being ambitious. This guy's just an idiot. I'm sorry. I mean, why would you throw away your career for such change? That's not what I'm really saying, you guys. If you're gonna throw your career away, at least say it wasn't for chump change.
I'm gonna say that.
I take that back. If you're watching this now, I really don't mean that. I'm just.
My dad got 40 minutes. Like, well, professor said I had to go big, so I just got the big number.
I'll email you back. Well, I'm proud of you. That's going to help you in court much, but I'm impressed. That was a good number. Okay, benefit the defendant as the measure of relief. How about that? That's kind of interesting, especially in a brute loss case. The benefit to the defendant was quite good in this case, I think, right? Even though he was not the person on the actual policy, right? But he just figured, hey, if they're offering, I'm taking. Is that true? That is true in this case. So here again, we have a very simple mistake case. Okay, not a hard thing, law, right? But here's the restitution aspect because they want back the value of what?
Somebody hit.
Pretty much. Can they really get that under contract?
No.
Why?
There's no contract.
There's no contract. Very good. Okay, who can give me this case quick? That's it, really. There's no contract in this case. You all did catch that, right? He's not the insurer. They just think he is because of a mistake.
A lot of mistakes.
Yeah, I mean, they're hard. They're hardly blameless. I mean, they're mistakes too. But, you know, again, you're sitting on a porch and the guy comes up and says, I'm here to paint your house. And you know damn well you didn't pay him. And that next door really needs a paint job. You tell him to paint your house. You think that that's right? No, of course not. So how could this case be right? Isn't it the same thing exactly? He knew it wasn't him, but he took the benefits anyway, didn't he? You all agree with me on that point? Any problems there? Something you never, any of the three of you would do, right? Okay, let's go.
Well,
Uh-oh! It's that kind of day.
yeah, it is that
Okay,
kind
what
of
do you think?
Okay, I agree with you 99% of the point until you said that he knew that this was not, okay, so
I think he knew.
the facts say that, in fact, his coverage had recently been terminated for non-payment of premiums. So he probably knew, maybe he knew,
But he wasn't the one paying the premiums.
but
so that
he was the person that came in, R is the son. Okay, so R is the son and T is the father, right? So I'm just gonna call
Yeah.
it R and T.
That's right.
R, the son, has all kinds of medical problems. He goes into the hospital, the clerk there decides that he is his father for no apparent reason and starts treating him, right? And then they mistakenly send different people, it looks like at least 6 checks, to the father, the son, and different people. The father, the son, and the father's business. Right, father, son, the father's business, the Holy Ghost. we'll call the business Holy Ghost. Why are they sending it to all these people? I mean, it seems goofy. I don't know. I mean,
I wouldn't overthink this
did they
case.
know that the kid didn't? It doesn't matter. The negligence is not negligence does not apply to restitution. Is basically the rule.
Well, it's equitable anyways. Yeah.
Right.
So they're asking for the value back. So in this case, there simply is no contract. Yeah.
Well, but it's not only about the contract. It's about whether or not negligence applies to restitution, right? Because it's the court's own negligence. I'm not the court's. I'm not getting tired. Sorry. The insurance company's own negligence.
I'm hot in here too. Huh? So
Yeah,
it's making
I'm
us
warm.
a little tired.
It's the insurance company's own negligence that caused all of this. And I think
That
it's
is
dubious.
true.
And I think it's dubious whether somebody entering the hospital whose insurance just ran out knows or doesn't know whether or not they still have insurance to cover them.
Mm.
You know, I mean, to me, this is
Yeah.
a pretty clear rule that you could be as negligent AF and you still get your restitution. I think that they were pretty negligent. I would roll my eyes and apply the law. To me, this is very negligent.
It's funny because I don't discount your theory, but what would you do then?
If you got 6 checks totaling more than $22,000 randomly in the mail for you to cash, would you not call somebody and be like, what the hell's going on?
Sure.
I mean, it's no different than like when I worked at the bank.
Repeat after me. No. Sorry. Absolutely not. It's an angry one.
It's like when I worked at the bank.
Sure, right, because make them come after you for restitution afterwards and be like, oh, okay, put it in the bank, let it sit there, and don't touch it. And if somebody comes knocking for
The
it,
problem is
Give it
I mean, some
don't
people
touch
do
it.
that. They put it in an interest-bearing account.
yeah.
People have been known to do that.
But it was like when I worked at the bank, we would have people that we'd have encoding errors and they'd get like a $700,000 check. And it was one like a $70 check. And they'd be like, oh, spending spree. And we're like, no, you gotta pay us back.
Well, there was a case like that when we were doing misrep, right? Where was a bank error, and this guy went out and bought everything with the money he got, and then he couldn't pay it back, and they couldn't get it for anything because there was no misrep on it.
Well, no, it's unjust enrichment. Well, that's in a legal case, but I mean, in equity, I mean, you can get restitution back.
Oh,
Oh,
okay.
yeah.
But if he's bankrupt, like you said,
Well, no, then you can't get anything. That's a loss of bank, and then people get
well, they're
fined.
gonna take all the stuff that you bought.
Yeah, but
Yeah.
you could go spend it, and
Well,
then be
no,
like, well,
yeah, I was
take
gonna
the
say, I mean, you can, you know, if you think about it, in some person's minds, the worst case scenario is, yeah, they'll take the stuff back.
Right.
Have it for a little while. And other people think that way.
You're also
They have it.
bankrupt for a long while afterwards.
Yeah, but now you do know in bankruptcy, you can't do that. You can't file bankruptcy and then like have like a pool table that you ran up at the end on your.
No.
You can't do. You guys know you
I don't know
can't do
where
it.
that pool table
That's
went.
not essential.
I don't know where that Ferrari went. I don't know.
I wanna consider that.
Someone stole it from me.
My
The day I got it.
I wanna consider that my vehicle exception.
Yeah, exactly.
It's not worth that much, right?
You take everything else, but it's mine.
Alright, let's move on. Okay, Somerville? Somerville, let's do that. That's
This one's easy. So, people end up building a lot for for Coke on their neighbor's lot, thinking it was their own. Their neighbor comes one day and says, "What the hell? Why is this on my lot?" So they offer that they want to have basically the building signed over to them. And the innocent plaintiffs basically just want to pay them for the value of the lot. And the court basically said when it's an innocent mistake, when you improved on somebody else's lot, you either give them how much the lot was worth, or they can go after you for, what was it? The rule's like massive. Within a reasonable time, either pay the improver the amount by which the value of his land has been improved, or convey such land to the improver. So they either get the improver either gets the value of what was improved, or they have to pay the value of the land before the improvement was made.
Doesn't that open the door to like just start building things on empty lots? Be like, oh, you owe me now.
Well, no, it has to be innocent.
Oh, that's true. How do you prove? You have to prove
Let me
innocence.
just run this by you. Okay, so here you are, you're in West Virginia, right? Here you are, and you own this piece of land, right? And here you are coming to see it, probably because you want to make sure that nobody's adversely possessing it, probably, right?
Now they
And nothing on it, right? It's in the middle, it's near a bunch of other warehouses and stuff, but that's the closest thing, I suppose. And then all of a sudden you show up and, well, hell, there's a big old brick building on my property. How did it get here? I have no idea. Nobody talked to me. I do a little research and I find out that Coca-Cola thought it was their property. Okay, fair enough. And they went ahead and built it. So what's your first impression of that? What do you think that the owner of the land should be entitled to? I never told them they could build it. Nobody asked me. Why do I care whether they knew it or not knew it? Aren't they benefiting from their negligence? Didn't I just hear that?
Yeah.
What do you think? I mean, do you really think that's fair that this land disappears because they're not going to pay them for the value of the building?
Yeah, I don't think it's fair because like, I'm not gonna pay for a Coke factory. Or
Yeah, I don't want a Coke factory. I'm good.
I mean, I would if I could charge Coke an exponential amount of rent to be on my property. I'd be like,
That's true. Gonna charge rent. Just kidding.
well, yeah, because you're now on the land.
Yeah, it's set up for a rent agreement, paying me this amount every 10 years. Now it's a rental property. But that's just me.
Well, I mean, you would think that would actually be the answer. It's like, well, guess what? I'll rent it to you. I didn't build it. I didn't tell you to. Here I am. I'm just sitting here. I'm like this is a drive-by shooting as far as I'm concerned.
I believe, at least in California, so I've heard a couple cases like this.
What do you think?
In California, the result is a non-exclusive easement. So they have all their rights to use their factory, and I have all the rights to use the whole land myself too. And that's where it ends in California. And basically, everybody looks at each other and go, oh, F, and they settle. That's,
Cause would you also be able to walk into the factory or something, or what do you mean?
it's a non-exclusive, that's
What does that
the
mean,
end
though?
result of this.
What does that mean then?
It doesn't, it always settles. I mean, I
It
do,
has to, because it's not workable.
it's not workable.
Oh, what does that mean?
It all, I don't know.
Work.
That's where the law, I looked at it in California, we've had a couple, they're all just fence disputes cases where like somebody built their, their koi pond over the property line and, like, what am I supposed to do? Like,
And it does happen.
yeah. And, some guy, whatever. But, yeah, the end result is in a non-exclusive easement. So you can't make them get rid of their factory. They get to use that.
And then you get to wander around the premises?
I guess. Yeah, you get to use it for all of your purposes, and they get to use it for their,
They're building on my land.
well, yeah, it's your land.
It also kind of makes you wonder, like, what would stop them from building another warehouse next to it?
Oh, well, you could probably stop them from doing that.
That might be a problem.
Yeah,
Now you
because,
notice.
no, there is rules on that. That
Yeah. Well,
they're
you're not innocent.
their rights to their easement is limited in, it cannot be enlarged at all. It's confined.
But you know,
But yeah, that's from what I can tell, that's where the
yeah.
line, the legal line. I mean, equity can be equity, but
Yeah.
that's where the legal line stops.
Interesting. What do you think about the idea? Okay, that sounds good. What do you think about the idea too, though, that maybe, I've actually heard this tried in somewhat similar situation. How about a nuisance suit?
Right.
What do you think about that?
There's a factory there.
Yeah, it's kind of what was that thing about enjoying my land?
Right. Well,
Trying to get in my way.
I brought all the nuisance allegations in the complaint, in both of them.
Yeah.
I
What did they say? Did it go anywhere?
no,
No
it,
traction?
the easement was the central issue, and it ended up settling, both of them. But I brought the nuisance allegations in both of them.
I'm just, because it's funny, because you would think that'd be a winner in this case. I mean, it's not a perfect fit by any stretch of the imagination, but even in this case, that doesn't sound so bad to me. The problem is you have a public policy problem, because here they have they built this place. Well, what are you gonna do, tear it down?
Right.
And again, so
Right.
that's problematic too.
Yeah.
We don't want that. I mean, when it's innocent, we don't want that.
Right.
So I think maybe you could justify it there, but I still think the nuisance is, you're a landowner, I mean, bring it into that. Bring it to court, But then again, if there's a statute there, you can't. That is what it is, right? Especially with real property, the statutes is law, it's just what it works. California, it's all statutorily.
Well, I think that's all based on decisional law, what I just said.
If there's no statute?
For the,
Ooh,
that it's a
really?
non-exclusive easement, that was the end result of, I'd have to look up.
That's very
It's been, these are some of the first things that we worked on, so it's been a year and a half or so.
Yeah, if you ever think about showing me some of your, if it's all closed and it's been filed already.
Sure.
Let me see it. That's fascinating to me. So they went on case law. That's actually kind of rare in California.
Oh, really?
Oh, yeah.
We're always on case law.
I mean, there's always some case law, but you always look to the statute first. And if there's a statute on point, that's the end of the story. The case law might help you interpret it if there's some wiggle room, but if it says 30 days, it's 30 days, stuff like that.
Right.
California's real property law is very statutory. So, cool though. I'm glad you brought the nuisance thing. Because when I looked at this, I always thought that might be another way to go.
Right.
On the other hand, you just lost your land. I don't know. That's a good one. I don't know.
Yeah, they always end up buying it for more than it's worth.
Oh,
That's the result. They buy the land plus the premium plus the cost of the suit. So if the land's like, let's say the land is really worth like $8,000, they end up paying like 30, and we go away.
Yeah.
Well, I've got this piece of land, you know what I mean? Like,
I want to build on it accidentally.
very happy for them to build it on an accident. Okay, with that. Okay, who wants to give me, this is an interesting, measuring restitution from the innocent and more restitutionary causes of action. So here you're giving restitution from the innocent, a little different in this case. Benina versus Shepherd. Notice this is 2017, one of the newer cases.
So in this case, we have a couple that's not married, but they're cohabitating. The lady, she bought a house in her name alone, and this gentleman's been repairing it, paying money to like gut the house, put new wiring and everything down. It's a total of about like, I think it said like, it was a lot. It's a bunch of little additions, and then when they separated, he brought an argument like, I want the money I put into the house, and she would be unjustly enriched if she were to keep all the improvements I made to it. And he made a list of everything he did, and then the judge kind of took off all the little stuff. Like he took off all the mowing the lawn, the painting the fence. He took all that off, and he just gave him the material stuff that raised the value of the house. And it was like $152,000 that he got in restitution because they weren't married, but they had gone to his house saying, "We're going to fix it up. We're going to sell it. We're going to buy a bigger one." That was his understanding of it. And they said that was okay. That's a good way to measure damages and give him relief. Like, the substantial, amount you put towards the value of the house, you can get that back, even though you're not married.
It's a Marvin motion.
Yeah,
It's something like that, yeah.
kind of.
Although notice how it falls through the cracks. So they have to go to restitution because it falls through the legal cracks. There's really you can't, well, plus this is California. But, even in California, this would be a tough call. I mean, here we have two persons who are cohabitating. There's no common law marriage in California. If they do have a Marvin type case, some kind of contract, that might not be bad. There's no putative spouse. There's none of that stuff, all that great stuff you're learning right now. So it kind of falls through the track. I mean, here he is putting all this money into a house that she owns that he's assuming he'll be able to have the value of it. And so, of course, it's all things that are fine until they're not, right? He gets kicked out. And now he wants his money back, right? So what do you give him? Do you give him, what's the value? I mean, it seems kind of simple. Restitution, I put this in, I put that in, I put this in, I put that in. He wants the value of living in the house. Does that sound correct? Or what does he want?
Which is money.
Well, but what does he want? Why isn't he happy with just paying me back for the repairs? Seems unhappy.
Yes, it's probably business. I don't know.
Yeah, that's what they're really arguing about.
I mean, he just wants the quantum narrow it, basically. I mean,
That's what I got. He just wants his money for the work he did.
it seems like a quantum narrow it type case because he just wants the value of the work that he did, even though technically it's all barred by statute of law. It's kind of like the next case, but
Okay.
yeah, he just wants the value of the work that he did.
Okay, and so
Yeah.
why is that a problem?
That's why is that abuse of discretion? So he gets the
Well, what was the
No, he gets it.
He gets it.
And it's unjust enrichment. That's what he was bringing the suit under, is unjust enrichment, stating that he did all this work and she didn't do anything for it.
Okay. So what is he arguing about? That's what I don't understand. But why are we here?
Because she didn't.
Well, what does he not want? I mean, I guess I could have said that backwards. What does he not want? Well, he's going to be paid, but
He doesn't want the value of the increased value of the home. He wants everything that he put
the
in.
case, very important point, right? They want to give him the increased value of the home. He just wants the money back for what he put in, right? So we're in equity now, right? Are there any actual rules?
Well, yeah, I mean, this is like quantum merit almost, right?
Oh, it is, yeah.
Yeah.
No doubt. So are there any actual rules in equity? I mean, is there fair market value? Is that what he gets? Or improvement of it? Is there any statutory law, or is it whatever is fair?
Whatever's fair, if it's an
This is the
equity.
judge's
Okay,
discretion.
so how in the world is the judge going to abuse his discretion.
Well, because
That's all I'm bringing
there's
up.
rules on quantum merit. I mean that's just.
It's more like quantum merit than anything else. I'll buy that. But remember, quantum merit is just, unjust enrichment based on value of labor, merit of your services. Whereas restitution is a little more like the value of the goods. But again, it sort of crosses back and forth too. So I'm not going to go into this. Depends on what jurisdiction you're in and things like that. Okay, so my bottom line then is, does everybody understand what's going on in this case? Okay? Yeah, it's kind of interesting. It's sort of a, live together case. And I don't know, Massachusetts, we're a pretty liberal state, right? So they shouldn't have too much trouble with that. All right, any other questions about that case? Okay, pretty straightforward. And it's funny because I had just recently heard about that case too, and then I got the new book and I'm like, oh, it even made it in the book.
Is it new?
I didn't put 2017.
Just an
Oh, wow.
interesting, case for people that are cohabiting, an interesting decision. Nobody really knew what happens when you do that. So, kind of odd. I think in
Do you think it should
California,
be a
you might
gift?
know.
Do you think it should be a gift?
Okay.
No, he didn't even get anything out of it now because they broke up.
Yeah, he's gone. Yeah, he's
He's not going to get half of the value of the house when she sells it. It's hers now.
Two nice things for people.
Damn straight.
Yeah, I don't know. All I can tell you is that, having, been married to a realtor, people put money in their home, fix it up before they sell it for this, so they get more. They add more value to it. So I'm kind of wondering what he did. They must have been very common, just upkeep changes and stuff
What he
like
did?
that. Yeah.
They added a second level to the house and
Yeah.
a couple extra rooms. It was not just common upkeep.
Well, I'm kind of wondering what he did because
Well, they found
why wouldn't that
$150,000. Like,
price up? You see what I'm saying? So, there need to be significant changes that would raise the value of the house quite significantly. But he wants the changes in the.
From 1999 to 2004, he spent almost $100,000. And then continuing on, he spent almost another $20,000. Plus he had paid half of almost $100,000 towards the mortgage payments.
And the value of the house went where?
Um,
You see what I'm saying? I'm like, I know people put money in houses all the time.
They purchased the home for $131,500 in
this happened right before the crash.
93.
Good point. Yeah,
You know?
I thought about that. Good point. It probably just crashed. Yeah.
He did this in 2005, 2008, and obviously in 2008, 2009, they must have broke up around 2009, right in the middle of the crash.
Well, no, they started doing improvements back in 93.
Okay, but look at when they stopped. Right,
Yeah, well,
right,
2008, yeah.
right at the beginning of the Great
Yeah,
Recession.
that's actually.
Well, they stopped those because they broke
The
up.
house was, that makes you wonder if she kicked him out because that was a good time to have the house value down. That's too evil. I can't do
I think that's the time that you look at all the money that you spent and go, wow, we just lost our butts,
Yeah, that's that, right?
And it probably is hard on the relationship.
No.
It's irrelevant. Rent equity, you get your money back.
It doesn't say how much the house is worth now,
Yeah.
It's worth way more now.
but I'm sure it is worth way more.
Right, but I bet the increased value of the home in the Great Recession wasn't nearly as much as what he put into it.
Well, particularly depending what I don't know what the housing value is in there, but some of the houses lost incredible value. So who knows? It could have been really bad. Massachusetts, I don't know. I have to look that one up. I don't recall them being one of the hardest hit states, but there were states that people were losing 80-90% of the value of their home.
I don't know.
So
But if it was worth $131,000 in an unlivable condition, it
that's interesting.
is now a 2-story home with multiple additions and improvements, and I'm sure that house went up to quite a bit.
Well,
It
but
must have, though.
him getting,
See but that's what kills me is you would think the value would have went up really high. So why does he want the?
Maybe
I mean, you think that he would want, it's probably because it's an easier claim to get quantum Merowith than to get the value of the
because the
house.
house isn't worth as much as he put into it, and so he wants a lot more than what, she probably wants more than half the value of the house.
It's
I mean,
also her separate property.
well,
I mean,
she's gonna have to sell it and give him a substantial, like $150,000.
Yeah, on the other hand, it's
but it's her separate property. There's no contract between the two of them. She's on title alone.
The court
They're not married.
is giving him the value of his services rendered, though.
Yeah,
Yeah.
because it's in not half the value of the house, which was probably more. Which I'm saying is the easier suit was probably the quantum Merowith than
Right.
half the value in the
But
house.
the reason why he wants the quantum Merowith is because it's greater. What?
I can't imagine.
speculative. That's speculative, right?
No, that is not
but
speculative.
it has to be, otherwise how could he want it?
Yes,
And that's what kills me.
Maybe he's not
It's
greedy.
like, how could
He's
that-
not-
He is not greedy. That's the thing, because it even says he could have asked for his whatchamacallit, his skill and labor, and he didn't. He only asked for the parts that went into it, like the cost of the materials. He didn't ask for skill, he didn't ask for labor, he didn't ask for any of that stuff. What they said he could have asked for, and it could have exponentially increased what he could have gotten from her. And he said, I don't want it, I just want what I put into the house.
Just wants a clean break, man.
So I think he just wants to be done with it, get out in the even.
but you're not making sense why this goes to the appellate level then.
Yeah, he must have been.
Because she didn't want to pay jack shit.
Well, then that's effed up. No, I think that she wanted to pay him the defendant next claims that the trial judge erred by measuring the plaintiff's restitution as the cost he incurred in improving the home rather than the value of the home. Sorry, rather than the increased value of the home with the improvement. See, I'm talking about
Yeah.
660. We disagree and conclude that in the particular circumstances, the judge did not use his discretion in determining that the plaintiff's costs in improving the home constituted a proper measure of unjust enrichment. The rule is your service rendered, right? And that's the rule for what you get. And the increased value of the home, I mean, that's like almost like a theoretical constructive trust kind of thing that you could bring maybe if you had better facts. But in this case, he doesn't want that.
Yeah.
He wants what must be a higher number. He wants
It's
what-
his case.
Yeah, yeah.
He's
So
complaining.
right. So it must be a higher number. What he put into the home must be more than what the home increased in value. Does that make sense?
I don't know if
And the only way to make sense of that is by looking at the dates and saying this is a recession case.
It makes sense, but the value, as I stated in the book, it can also just not be greedy.
Well, the rule is that you can get the value of your services rendered if you put a bunch of work into someone's house with expectations like that. I don't want to do the last case. Can you do it for me, Vincent? Please. I know it's my turn. We got 5 minutes.
Promises, plan for
Does everyone understand Parash?
Yeah.
Just give me 2 lines if I'm huddle. Give me 2 sentences. If it's good, we're done. It's not a hard case.
I don't remember the fact. There were no.
It's really
Oh, dude. Police a building owned by it's a quantum Merowith case. It's saying that you can bring a claim for reimbursement that is not barred by the statute of frauds just based on quantum Merowith, so long as you have a reasonable reliance that there's a valid contract, even if there isn't a valid contract. The rule of the case is basically that a quantum Merowith claim is not barred by the statute of frauds.
Yeah? Everyone agree?
Yeah.
That's right.
Okay.
Okay, good. It's a statute of frauds case.
Okay.
The claim is not barred by the statute of frauds.
No.
Good. Okay, I'm good. Because they're connected.
Yeah.
Good then. That's not a good case. Now I gotta read this case again because of you guys. Now you got a question in my mind. I gotta read this again. This is the
That was a
kind of
good
thing
period.
that's
It's the
fun.
recession is the way it is.
Yeah, it's got to be something like that in there.
I guess, but I just can't see that the house didn't increase by value enough. From 131,000 for an unlivable condition, you put almost
No, that's why most
$300,000 in renovations into it.
I mean, they gotta figure it was pretty.
Well, no, between the two of them.
That's what I keep thinking.
No, but that's how most serious cards when during the recession, people thought it was gonna go up, so when. Yeah.
Yeah, but still, it was an unlivable
But
and it's not like they bought it at the height of the housing market. They bought it in '93.
But it might have gone up. Well, no, it's only but it's not from the value of, from when she bought it.
Yeah.
I agree. No, it's the value of how much did her.
How much did the value of the home come from the time that they bought it to the time that they
No,
would sell it? That's
from
the increase in value.
No, at the time of, he started his improvements till the end of his improvements.
Okay, so he started the improvements as soon as they bought the house. Because they bought the house together.
I thought it was like
Except-
05.
No, they were together in '93.
What was it?
They bought the house in '93, started the improvements in '94. Bye. To bring it to a livable condition.
I just have that sickly feeling we're missing something.
And he even started paying